Good morning, everybody. Happy Tuesday? Yeah, it's Tuesday. Welcome to TCF Live. Good to have you all here. Getting started just a few minutes early. We'll kick it off in Michigan. Judge Middleton.
Michael Graham.
Yes.
Mr. Graham, you got a ticket for driving with no insurance. We get lots of those. Sometimes they're coupled with no registration. Driving with no insurance is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $500. Carries not less than $200. Welcome to Centerville. Good morning, sir.
Oh, I'm sorry, Your Honor. Well, good morning. I'm just checking in. Haven't been here in a while. I have a 8:30.
Yes, I've got the pre-exams also. I've got a number of arraignments. You and I met over the Zoom feed, but check in with the prosecutor. And you win the best dressed award today, I think. So you got that going for you. So I'll see you in a little bit.
Thank you, Your Honor. Be right back.
All right. Mr. Stickley, you come in a close second, but they dress better in Detroit, I think. Anyway, Mr. Graham, the question I ask everybody is, do you have insurance now?
Yes.
Do you have it with you?
Yeah.
All right. Who's your insurance carrier?
Cure Auto Insurance.
Do you have it on your phone or?
I have it printed out.
All right, very good. You have a seat. We'll refer to the prosecutor in a bit and see what we're going to do. Let me just tell everybody now, if you're charged with no insurance, it's a misdemeanor. It's punishable by up to a year in jail. It requires you be fingerprinted. It carries a minimum fine of $200 plus costs. Very usually, when the people come in and show that they have insurance, the prosecutor is willing to dismiss the misdemeanor charge for a plea to a civil infraction called no proof of insurance. And no proof of insurance is punishable by up to a fine. It's not even a crime. It's a civil infraction. The fine is $150. So why don't you have a seat? We'll come back to your case when we get a break. Mr. Stickley will touch base with the prosecutors. I lost Mr. George for a minute. He's the Three Rivers City attorney. It's very helpful to have him here. And sometimes Mr. Reed on behalf of Sturgis and Three Rivers, because they can help me make decisions right here in the courtroom. Let's talk to Lynn Marie Kelly. Ms. Kelly, would you come forward? Good morning.
Good morning.
You got the same ticket as the last gentleman, no insurance. And as I mentioned, often this is coupled with a registration plate charge. And so you're charged with that.
Not yet. I have an appointment for the DMV. I'm waiting for the title to come in.
So I'll ask you the same question. Do you have insurance?
Yes.
Your Honor, she doesn't have her, the plate is in process or sort of a title issue. It might behoove us on this one to have her come back, even though it's kind of inconvenient, and get some sort of a global resolution, because then she'll have both, just saying.
All right. So you have insurance, but you're working on getting the plate straightened out.
Yeah, I'm waiting for the title.
How long will that take?
I got it from my boss. He filed for a lost title, and we're just waiting for him to get it in the mail. I don't know how long it takes.
All right. Well, I think Mr. Stickley's advice is probably good. If we adjourn this and you come back in and show you got a proper plate and proper insurance, prosecutor is very likely to help work out something out that won't be so expensive.
Okay.
Are you missing work right now?
No.
All right. Well, let's set this out a couple weeks. February 17th at 8:30. Is your Schoolcraft address still correct?
Yes.
Good morning, Miss Harden. Mr. Rainey got himself arrested last night. He failed to appear on that MDOP case.
I think he's got a warrant for arbitrary circuit court too.
So while you're here, I thought I would at least at some point zoom him in. Have you got a commitment to be someplace else?
I have sentencing with Judge Patterson at 9.
All right, we'll fit it in sometime while you're still here this morning. He's not going anywhere. That will be Tuesday, February 17th at 8:30. Bring proof of insurance and plate. If you got convicted of all of this, the minimum fine would be about $525. So that's money better spent on getting your plate and your insurance. And then I'm reasonably sure the prosecutor will give some consideration. So let's try again in 3 weeks, see if you can get your plate straightened out. And you're good to go.
That's it.
Mhm.
Thank you.
Excuse me. We do have a bunch of pre-exam conferences, which are felony cases that are theoretically set to start at 8:30, but it isn't generally possible to do all the misdemeanor arraignments in 15 minutes. I still don't have Mr. George, so let's keep going here. Stuart Udvardy, please come forward. Good morning, sir. You got charged again with driving with no insurance and driving suspended. The file number is 2681SM and 269 or 82, I guess. You have paid all your previous fines and costs, but you keep getting the same charges.
This time
Go ahead.
I had to leave work early and I had to go to the hospital.
All right, well, don't say much about, are you still working at Metal Technologies?
Yeah. I was headed to the hospital.
You headed to the hospital? Well, there's a defense for driving suspended if you are going to a medical emergency. You could end up going to jail for this because you've got so many of these. My recommendation, and probably Mr. Stickley's as well, would be that you plead not guilty, get a lawyer to help you with this. Is that acceptable? Are you missing work right now?
No, I worked
Third shift?
Yeah.
So you've been up all night?
Yeah.
All right, let's take a look at your ticket.
Yeah.
Find you, there it is. It's 3 o'clock in the morning, Broadway and Constantine, which is kind of on the way to the hospital. Stop for running a stop sign at Constantine and Broadway. Said had no license and the car was not insured. All right. Plead not guilty. Says he was on the way to the hospital. Was set an attorney pretrial. For March 6th. These first Fridays of the month have just become so dense. We have 75 cases set for Friday with about 60 defendants. And that's a lot to try to do in one morning, but that just happens each month. We have more and more cases. Anyway, Mr. Udvardy, I'm gonna get you a lawyer to help you with this. I know you've got an explanation, but I want you to save it. You can share it with your lawyer and they can share it with the prosecutor's office. As I said, I don't think you owe me any money. You've paid all your obligations to the court,
Yeah.
but you got a lot of baggage on your driving record. So you go to the court officer and, no, that's the no insurance case. Amanda Sawyer. Good morning. Are you Amanda Lee Sawyer?
I am.
Miss Sawyer, you're on the same boat as our other no insurance cases. Your case is file number 252711 SM. Doesn't appear that you owe the court any money, but you were also charged with no insurance and no valid registration or no valid operator's license. One is under state statute, one is under ordinance. Do you have insurance now?
I do.
And what's the status of your driver's license?
I just renewed my permit again.
All right. Who's your insurance carrier?
Direct auto.
All right, we're gonna need help from both the city attorney and the prosecutor. Have a seat also. The fact that you got insurance is good. The fact that you got your license straightened is also good. We do have a couple of pre-trials this morning and Ms. Stoll is probably working on. Those are set for 8:30. All right, still no Tim George. So these last are ordinance
He's
cases.
in the building.
Yeah, he's probably working on his other stuff. And in the meantime, it's Mr. Reset's file. This must be stuck to something else. Oh, that's a felony case. William Huey.
Well, the next contestant lines up. Good morning once again, everybody. Welcome to TCF Live. Good to have you all here. Slow start so far in the courts this morning. There's only a couple of things up and running, but I've got my eyes out as I always do. We'll continue to ride with Middleton for a little while.
You're William Christopher Huey.
Yes, sir.
You've met before, but I need to identify you for the record. Mr. Huey, this is file number 26-51, ordinance case. Generally, the ordinance offense is punishable by the same punishment, fine and cost and potential jail time as a misdemeanor. Good morning, Mr. Bland. I didn't know you were scheduled to be here this morning. Who are you representing?
I'm subbing in on Xavier Eddington.
Oh,
I'm
Eddington.
subbing for Mr. Gibson. I don't know if he's here yet.
Uh,
I sent him a sub, but he hasn't signed
is
it.
Mr. Edgington in custody?
Sir?
Is he in custody?
No, sir.
Oh, very good. Okay, well, it's nice to see you.
You too.
Mr. Huey, let's take a look at your ticket. You got an old unpaid careless driving ticket where you owe $234 from 2021. You have an unpaid booking fee, but I don't much care about that one. It could be the wrong William Huey, so we'll take a look at it. There's more than one, as you know. Let's talk about this ticket. It was at 2 o'clock in the afternoon on January the 9th, 4th Street in Michigan. No other notation on it. Shows your driving privileges are revoked. I just saw you last year. And that careless driving ticket is still on there as unpaid.
Yeah, I didn't know nothing about that,
I thought I told you last time, but perhaps not.
but I can pay that today probably.
Oh, that would help. That would help a lot.
I didn't know nothing about it. I thought I had all my stuff paid up.
Last time in September, you pled to driving suspended. Paid the fine. I can't tell whether I reminded you. It was Judge Pattison. Have a seat, Mr. Huey. When Mr. George, the Three Rivers City Attorney, comes back, we'll let him talk to you for a minute. Darcy Bess. I was holding off on these for Mr. George.
Barbara, thank you for gifting a membership. I'm pretty sure this is the second or third time American Smokers gotten the gifted membership, but thank you.
You got a ticket at Walmart where everybody gets their ticket for retail fraud. That was on January the 10th. Retail fraud, I think this is intended to be an ordinance case. It lists Mr. Reed as the attorney. And I don't know a thing about it. Under ordinance, retail fraud is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Doesn't appear that you got anything pending here. You're from Cassopolis?
Yes, sir.
All right, I'm going to ask you to have a seat for a minute and we'll wait for Mr. George to come back. Three Rivers does have a civil infraction that could perhaps fit this. Kevin Lyle Beebe.
Told me to tell you, I paid my ticket.
Good.
When I owed $200,
Well, good. That's the good news.
I
The
didn't
bad
even know I
news-
had warrants. My brother's,
You
my
got
brother's
two
wife
warrants,
was
though.
actually BB. She works for 911. She told me about it. I was like, what? So I
You
came
got
and took
two
care of it.
open warrants, so let's talk about all this. You're here today for an arraignment on a charge of disorderly person from September 11th. That's file 251903. You didn't show up for arraignment.
Yeah, that one I moved to Florida. Then I came back
Brother
and went to
called-
rehab for my alcohol. Then
So-
I forgot about it.
Let's look at the first one.
Not to interrupt, but I'm going to interrupt. Lindsay, thank you for gifting 10 memberships. Lindsay had my back yesterday, and I called that out in the pre-show today. And all of you, I just want you to know that y'all mean a lot to me. You tune in every day, you watch, you've got my back, you're very supportive, and I just appreciate all of you. So Lindsay and the rest of you, thank you so much.
Beginning of December.
What's your new job?
I'm working at Summit Polymers. I'm actually making car parts for police cars, the dashboards, the Ford Explorers, the 2026 ones.
Well, this
Yeah.
one was, holy smoly, the one
We
in
make all types of different
September
ones, too.
11th,
Most
public
Ford Explorers.
intoxication somewhere, you were point 368. Did they
Yeah,
take-
I went to rehab though. I went to light
Did they
recovery
take you to the
center.
hospital?
I
They're
don't,
supposed to take you to the hospital if you're above 3.2.
I don't remember. I don't think so. I don't really remember.
At point
I don't know, it was a long
383,
time
if they put a wick in your mouth and lit it, it would burn.
ago. Yeah, I know. That's why I moved to Florida for a little while. Then I came back and I went to rehab. And then my brother's wife works for 911, Ashley Beebe. She told me, "Oh, you got warrants?" I was like, "What?" So I looked them up, man. And I called you guys to get a court date to get this stuff taken care of.
All right.
I don't know
Where did you go in Florida?
Miami.
Warmer there than here, but it's a lot more expensive.
Yeah, I know. That's why I came back because I couldn't afford it down there.
All right, you have an open warrant for another disorderly person in file 251299. That's from July 1st of 2025. That actually precedes the September case. And the other warrant is on the same date. No, 2 days later, September 13th. 252536 OM. 251299. Miami's full of rich people and poor people.
I know. Yeah, I know. It's mostly all poor people, but unless you go downtown. But I couldn't afford it down there, so I had to
All right, I'm
come
gonna
back.
arraign you on all cases.
I have no clue where the retail fraud came from because I
Well,
was
let's take a look at it.
never arrested for it.
That was the 13th. Sometimes they'll review a video or something. Let's see what the retail fraud is about.
I don't think I'm stealing anything.
3.6. It allegedly occurred at Walmart on September 13th.
Hmm. I don't know.
Oh, yeah. They followed you. You came out of the bathroom. This is all on video. You took allegedly some boots, 68.98, a Lunchable grilled cheese, 3.98, some Klondike Reese's 6-pack, 73.18. They have a video of you walking in the store and walking out of the store with you wearing the stolen boots.
Hmm. I
So
must have been drunk.
well,
That's why I
maybe
quit
so.
drinking.
All right,
I just don't want to lose my job. I kind of want to get all this stuff taken care of too.
All
Paid the
right, well, I'm gonna
$200 for it.
recall the warrants.
Thanks.
I'm gonna appoint an attorney. Let's see what else we got here.
That's
You
what-
don't seem to have any, oh yeah, you do. You paid that $200 fine today?
Yes, sir.
All right, very good.
I got about $50 left in my pocket.
All right, you presented yourself at the court on these warrants. You paid an outstanding fine. So it shows good faith on your part. You're back in the community. I'm gonna appoint an attorney. Set attorney pretrial for 3/6/26 at 8:30. I have lost Mr. George. For those other pretrials. All right, you go out to the counter. We'll get a lawyer. What shift are you working at Summit?
Second shift,
All right, well, you won't have to miss work.
12:30.
That's expensive living at the
Safety
motel.
last night because it run my head. There we go.
All right, the ladies at the counter are gonna give you your attorney's name and number. I want you to call that lawyer, make an appointment to discuss this matter with them prior to March 6th, and I'll see you at 8:30 that morning.
All right, sir. Thank you very
All
much.
right, let's talk about,
Great Granny, thank you for the $5. You say I like TCF because you can listen in peace. Well, thank you. We try to do that around here. Just have a place where people can gather and it's welcoming and enjoyable. And but we're still watching some serious stuff. But I'm glad you enjoy it, and thanks so much for being part of the community, and thank you again for the super chat. All right, good morning once again, everybody. TCF Live on a Tuesday. It's good to have you all here. Let's change it up. We've got some other courts starting to come online now, but let's stay in Michigan, go over and say good morning to Judge Dad.
So what happened here?
So Ms. Vander, I don't want to mispronounce it, I apologize, came into the dealership to purchase a vehicle. And when she purchased that vehicle, she was supposed to bring back a cashier's check for the amount that she owed, and she never did.
Did you sign the title over?
We did, we stated the car. She.
Wait a minute, you signed the title over to her?
Yes, we
Did she register it with the Secretary of State?
Yes.
Why would you do that before you got the money? Or was this a later payment, balloon payment at the end?
It was, if you look on the attachment, sir, you'll see the payment plan that she organized with the dealership.
Jeez, I see. Okay, good enough. So she owes you guys, she got the car, she didn't pay for it. You still are owed $6,216. And 60 cents. You should have some court costs too. Can you give me a breakdown of those? I need to know what you paid for.
For Dino, it was $75.
Okay,
To file our court fees was $70, sir. I have those receipts with me.
so 75 and 70, right?
Yes, that's correct.
So that's $145, and on top of the 62, 60. So that should be another 145. That should be 63, 61, 60, right?
That's correct.
All right, judgment is entered. I'm going to give you a copy of, I'm going to ask you to go down the hall. Just give him a couple minutes. He'll bring the file down. I filled out the judgment for you and you're all set. I hope you can collect that. Best of luck.
Thank you, sir.
Is Flat Rock out there? People again, Sterling, Joseph Wright, 25W84088-1A and B, and also 25F244059. Good morning, Mr. Wright. Your name? Muted. I can't hear him.
Good
Your
morning, Judge Sterling Wright.
All right, officer, your name?
Officer Porter.
Yeah, I'm gonna ask you to take your hat off if you would, Mr. Westmoreland, your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Wright.
So we have a charge here of disorderly person, public intox, and minor in possession from November 22nd. He was in front of me on December 11th. The case that he was in here on November 22, he didn't show up for on December 17th. And he also has an open intox. Where's he been?
Your Honor, he's currently living down on the road and he didn't have,
All right. I see. Where was he picked up at, officer?
in Flat Rock. That I'm not sure. I believe his address is in Flat Rock. So,
Right. You didn't graduate, did you, son?
No, I did not graduate from high school. No.
I can't hear you.
No, I did not graduate.
You're not in high school anymore.
No, I'm not in high school anymore.
Are you working?
Yes.
Where?
In Flat Rock. I move furniture.
For who?
Work for a moving company.
Which one?
Wheel Deal Moving.
Will Deal Moving?
Wheel, like WILL. Wheel. Wheel Deal Moving. I
Yeah.
also work for other companies as well, though.
You know why I knew you didn't graduate?
How'd you know that?
Because when you act this irresponsible, there's no way you get through high school. No way.
Mm.
How many hours do you work per week?
Maybe around 40.
Maybe around 40. How much do you make per hour?
$20.
You make $800 a week. That's pretty good. Is that how much you
Somewhere
make per
around-
week?
Somewhere around there.
Why isn't he showing up besides the fact that he didn't have a ride, even though his parents live in Flat Rock and he works out of Flat Rock? That's just an excuse, isn't it, Mr. Wright?
Absolutely not.
Oh, it's not an excuse? Well, then we're going to make sure you got a ride to court. How's that? I'll make sure you have a ride to court. And they can take you over from the Flat Rock Police Department when I get ready to handle this, okay? And then you're going to have to post a high bond. So, you know, don't tell your lawyer things that are not true. Okay?
Your Honor, I think he acknowledges, and he meant to say was, it's not a good excuse, but he understands. After I spoke with him, he does understand the importance of the hearing and making sure he clears all these matters.
So he's got a November 22 minor in possession. He must have a prior minor in possession, right? Yeah, that's what that says on the ticket. That's why they charged it as a misdemeanor. So you have that case. Give me 1 second, if you would, please. You've been in front of me before. I remember you. You know what? You have been, right?
Think so.
In fact, you were in front of me at the Flat Rock Police Department, sitting there just as you are now, right?
No, I don't think that was it. I think I had came in to come see you.
You'd come to Flat Rock, or you came to the court?
No, I came to the courtroom to see you. I was in court when I see you.
You gonna grow up, or you gonna act like this your whole life?
No, I'm really ready to figure this out and make it to where I don't got these warrants and I don't have all these fines, and we can just put it on one accord to where I can just boom, boom, boom and knock everything down, and just instead of having warrants here and being, and keep going through this process.
Yeah,
It's not.
Yeah, well, you're bringing this on yourself.
Well, I wasn't sure about a warrant. Like I didn't know how that worked really. I wasn't knowing, you feel me?
Do you stand mute and
So
wait formal reading on the failure to pay, which is 25R514323?
That's correct.
it's a mute on there. We muted.
You missed too many times here, son. John, you're gonna have to go over there. We're gonna have to do a screening as I ordered quite some time ago. So here's what I'm doing. Anything else, Mr. Westmoreland?
Not at this time, Judge.
Well, I'll give you an early court date. I'll do that because I want to be a lot more fair with you than you have been with us, okay?
Okay.
Is that all right with you or?
Yes, yeah.
Keep doing this. I don't get it. You've missed court 4 or 5 times here. 1,510% on 25F244059. We're gonna need a screening and assessment and probation, John, to get on to do screening on 25F244059. You have 210. I'm entering a not guilty plea on 25R514323. That'll be $100 cash. I will set that for January the 29th, and that will be at 9:15. And then on Judge Hessen's cases, you have an open intox and you have a minor in possession. 1,010% on that. No contact with prosecution witnesses, no alcohol, no marijuana, no illegal drugs. Do you understand all that? And that's on both the open intox and the MIP. Do you understand that?
Yes, Your Honor.
So that'll be on January 29th at 9:45, the pretrial on that. So you got a contempt hearing in front of me, a sentencing in front of me, and then you've got pretrials in front of Judge Hessen on the 29th, and again, that will be at 9:45. Okay? You cannot leave the state. You cannot violate a law. You must appear in court as directed. You need to get to court on time, sir. Okay? Don't be late. We understand one another?
Yes.
Thanks.
His probation need to zoom in.
And we're gonna give you, yes, probation needs to zoom in with him, officer, so if you'll just bear with us. And we'll get you, tell him, John, tell whoever down there, I want him to have a court-appointed lawyer. Trenton Federal.
Great Granny in the chat. What's MIP? That's minor in possession is what that is. Barbara, thank you for the $10 super chat. In it, you say, Lindsay, be proud. So congratulating Lindsay. And then you say, I'll be clean 38 years in March. Congratulations to you as well. And again, thank you for the super chat. Lindsay referenced Will Deal Moving in the chat, saying they did not have great reviews. I just looked it up. She's right, at least on Yelp, only 2.5 stars, though they do fare a little better on Google reviews. Anywho, let's continue with Judge McNally for a little bit.
You do have the ability to do this. It's based upon whether or not there's any undue prejudice to the defendant and whether or not there's a purpose or reason behind this petition. And really, there's no doubt this is administratively, my office failed in renewing this judgment. I took a look at the history. I've represented Shore to Shore or Trenton Federal.
Where does it say anything about prejudice, though? I'm not trying to give you a hard time, but I just can't do this. Unless she made a payment, in the last 10 years,
Judge,
and you can document. Go ahead.
Sorry. Go ahead, Judge.
Oh, go ahead.
Judge, there's nothing in the court rules that says you can't do it. And I will tell you, and again, I represent a lot of credit unions. We do a very good job of monitoring these files. We lost a few of them during COVID, and really going in front of district court judges, what you indicate is one, they haven't made any payments. Two, the fact that this doesn't put any prejudice on them because they're debtors in the sense that they owe plaintiff money. And three is the fact that because of the need to collect this money, the credit union is asking for discretion from the court. There's nothing in the court rules that says you can't do it. What it indicates is that in order to do this, in order to renew a judgment, you have to go in front of a circuit court or district court judge. So what happened here, and I'm going to tell you that it's unique, and I'm suggesting, or I'm not suggesting, I'm indicating it's my fault, it's my office's fault. Prior to the extinguishment of the judgment in 2017, we filed the motion to renew in front of this court. And we filed the motion to renew, we paid the filing fee, and we prepared an order to renew in 2017, a month before this judgment was up. At the time, my legal assistant, my longtime legal assistant, had moved to Illinois. She was working out of her Illinois office. And when I saw what was going on with this file, I had asked, sorry, I lost you just now, hold on. I had asked my office that we were going to pursue this judgment, and she indicated that we couldn't because our order to renew had never been entered by the court back in June of 2017.
You sent it in?
Yeah, June 15th, 2017, there was a motion to renew, order to renew, check in the amount of $20, and it was for my legal assistant. She had sent it from Illinois, she was basically working out of her house out of Illinois. I thought this was renewed. I thought it was a live judgment, but sometimes what we do is with these debtors, we put them on hold because they might resurface. And when I knew my 10 years was up, which is now that we're in 2026, I asked them to renew it again because now this defendant had resurfaced. And so my client wanted to pursue her. The judgment's only $3,000, Judge, right? So I was of the opinion that we had a live judgment, and pursuant to your court record, not yours specifically, but the court record, it indicates that this order, this ex parte order, was never entered back in June of 2017. So I come before you today in January of 2026, suggesting one, she has not made any payments. Two, the judgment's $3,500. Three, I was of the opinion and position that we had a valid judgment. And only
You're asking me to do something I just can't do. How can I do this? I mean, I feel for you. I'm sorry. I can't just make my own rules. There's nothing that I know of in any rule. If you want to take a few minutes and pull it out and read it to me and tell me the rule, I'll be happy to listen. But the fact is that there's only one or two ways you can have a judgment renewed. One, within 10 years. And secondly, if not within 10 years, within 10 years of the time that the defendant last paid something. So if you want to spend a few minutes and find the rule and read the rule and tell me the rule, I'll be glad to, but I don't know how I can do this. In the meantime, I'm going to ask you, Linda, to check this file. This should have been still a hard copy file. And you check this file and tell me whether received anything back in 2017.
Yeah, Judge, the letter is dated June 15th, 2017. Went to the clerk of the court at 33rd District Court. It shows that you received it. It was stamped received by the court June 21st, 2017. And you cashed the check for $20.
Okay.
However, Judge, and again, I'll do some research on this. I will tell you, and again, you are correct that there's two ways that the court rule is prescribed. However, the court does have discretion. And
where does it read that rule to me? Read that rule to me. I don't think I do. In the meantime, you listen. I want to do it, but I can't unless we have the paperwork. If this was an oversight on our part, that's different. If we somehow threw this in the garbage or something, or they didn't bring it to me, and I don't mean to be facetious, I know this is serious and I want to be able to do this. I'm going to have her check. You pull out the rule. I'll go on to another case and we'll go from there. Okay. LVMV versus.
No, Judge, I'll step off. I'll brief it and I'll get you something, and we can just set it over for a week.
Just come back in an hour. It shouldn't take long. They're going to check right now.
I will check for you.
If they've got it, I will see it, okay? You come back, when do you want to come back? 10:30? She's not here. There's no
She's not.
prejudice. So you
10:30 's
can go
fine.
ahead and go ahead and do that and come back on at 10:30. LVMV versus Tory Parker.
All right, friends, good morning once again. TCF Live. It's good to have you all here today. Programming note, we are not doing the TCF overtime, the 4th hour today. I have other matters that I have to tend to between this show and tonight's sidebar, and I need that extra hour. So it will just be a 3-hour show today, but we'll come back tomorrow with the 4th hour. But I wanted to show you guys something. I'm not going to this court. This is Judge Brown, and it wasn't overly compelling what he was doing there, but I don't know if you notice in the lower left corner of his feed, the title of his YouTube live stream was Jail People. Now, I don't know if that means that he's dealing with people who are in jail or if that's what his intent was going into his docket, but I just found it funny, so I thought I would share. Let's rotate back over to Judge Middleton.
I also have an appearance. File that with you too. That's fine. I have one that's photocopied. And then I'm going to be asking to adjourn the PEC. Josh said it was okay with him. Do you want me to call my client in or?
Please, we'll shift gears here in a minute. We're wrapping
Oh, I'm
up.
sorry if I got you in the middle of something.
Well, we're finishing our misdemeanors, then we'll shift gears to the felonies.
Okay, thank you.
Mr. Stickley, this might be a time to see if you can find Miss Stoll regarding these cases.
It's like, for now, we just have the 2.
We have Miller, Huey, we need Tim George.
Yeah, and Graham.
He's in one of the conferences.
Yeah, we'll leave this out. So do you need these files?
Yeah, I'll grab that.
Ordinance.
She's in the back.
Who?
Is stolen back.
I don't know. I'll go check. All right, anyway, Elizabeth Conway is not here. She's charged with disorderly person. The address listed is a 7th Street address that she does not live at. She's been evicted from there. There's no sense doing a show cause. This was at the hospital, and I think she'd been previously trespassed from there. Bench warrant. $250 cash or surety, 48-hour hold. She has a number of unpaid fines that frankly we probably should have wiped out with some previous jail sentences. She is struggling with some significant mental health issues, and I'm not at all surprised that she's not here. If anybody knows her, sees her, tell her to get in here. She's got 48 hours. I'm going to issue a bench warrant for her arrest. Abigail Cowgill, not Cowgirl, Cowgill, Noah Lake Road, driving suspended. No phone number. Oh, yes, she has an improper plate.
They're fine, no problem.
All right.
Call called and reset.
All right. All right. Then we have Lindsay Miller. There's currently a warrant for her arrest. Lindsay Marie Miller. Don't need 2 warrants. Do you have anybody in the back?
Patricia Weaver.
All right. Lindsay Marie Miller has failed to appear. For arraignment. There's already warrant out. Warrant remains out. I do have a couple of phone numbers, but I don't have time to dial up this morning. Ms. Harden, when are you here next? Next week?
Next Tuesday. Duty week.
Good morning, Sergeant Herman. This is Judge Middleton. Could I see Eric Rainey, please? All right, thanks. Bye-bye. All right, well, let's talk about our civil infraction cases. Ms. Graham, would you come forward, please? Or Mr. Graham? Who did you talk to, Keith? All right. Mr. Graham, we return to your case, which is file 252731. As I told you earlier, you got charged with no insurance, which is a fairly significant charge. The prosecutor agreed to dismiss it. I don't have the authority to do that. The prosecutor does. But when people like you come in and show that they do have their insurance, the prosecutor is willing to reduce this to what's called a civil infraction of no proof of insurance. You don't plead guilty or not guilty to a civil infraction. You simply admit or acknowledge that you did not have significant, or you didn't have proof of insurance in your car at the time of that traffic stop on December 26th. That accurate?
Yes.
I don't know Cure Auto Insurance, but I'm sure they're legit. Fine and cost. Is $150 per fee schedule. Can you pay that today or do you need time to pay it?
I'd get paid on Thursday.
Well, I don't want to take your whole check, but generally I'll give you 30 days to pay it. Can you pay that with 30 days from today? All right, I'll give you an envelope. 30 days today is February. We'll go to the end of the month. Nope, it's 27 is a Friday. You can pay with a credit card. Send in a certified check or money order, or you can just come in and pay green cash. But we appreciate the fact that you are now insured. You can pay that civil infraction fine. This matter is done.
All right, friends, let's change it up a little bit. We have not been here in a hot minute, as the kids say. Let's go down to Miami, Florida. Say good morning to Grumpy Pants, Judge Mindy Glazer.
Yeah.
With the evidence, $1,000. All right.
Thank you, Your Honor.
You have a good morning. This nobody tells you.
Thanks, Judge. Your Honor, you said 1,000?
Yeah, I did 5,000 and 1,000. Okay. Good luck to you, sir. Next, we have Santiago Chavez on page 6. We have a private lawyer here. Good morning.
Your Honor, for Mr. Chavez, Jack Palmieri, PALMERI. Good morning to the state.
Morning. Spanish, please. All right, good morning, sir. Mr. Chavez, you were arrested for armed robbery with a firearm or deadly weapon and aggravated assault with a firearm. This is a case from January 7th of 2026. He has a hold for immigration. He needs a Spanish interpreter, please.
I apologize. Did I hear that there is an immigration hold?
Yes.
Okay, thank you.
Jackie, we can't hear you. I cannot interpret. So I can't hear anything you said, Jackie. You can either log on and off again or get another interpreter because I can't hear you. Can you hear her? Miss
No, Judge, I cannot hear.
Or just now. And I can't hear Jill either. Okay, Miss Corey can't. Okay. I gotta pass the case till we have an interpreter that I can hear.
Yeah, thank
So
you.
Jackie, either log on, log off, or get somebody else. Next, we have, I gotta give me a minute, Mr. Palomari. Alexander Vio.
So I'll try to get another,
You wanna call
device.
Judge, I can hear her, but very low.
I can't hear anything. Good morning, Mr. Vio. Do you speak English? Yes. Sir, you were arrested for burglary to an occupied dwelling. I will, sorry, your attorney is here. Let me promote him now.
Your Honor, what page is he printing on?
Page 9.
Thank you.
It's from yesterday, January 20.
Good morning, Judge. This is Attorney Davis. On behalf of the review.
Can you accept a promotion as a panelist and put on your video?
Oh, yes, ma'am. I'm sorry about that.
Good morning.
Where is my camera? 1 second, Judge. I don't know what's going on today. I don't know. What happened to my camera? I'm going to log in from my phone, Judge. I don't know what happened.
I see a camera showing the ceiling, I think.
I
It
know.
looks like the floor.
Okay, here we go.
Good morning.
Good morning, Judge. How are
Okay,
you?
what is your first name? You got
Sure
a
thing.
yes?
First name is spelled D as in dog, A, M as in mom, E, K, A. Last name is Davis. Good morning, everyone.
Good morning, Ms. Davis. So Mr. Vio was arrested for a case from, is it the 20? No, it's from 2023.
Yes.
January 28th, 2023. The charge is burglary to an occupied dwelling. So I'm reviewing the arrest affidavit. It looks like there's probable cause for burglary with an assault or battery.
And the defense has no probable cause argument, Judge, just
I mean, I'm going to find probable cause for burglary to the occupied dwelling. All right, it's from 2023. You're ordered to stay away from the alleged victim, Jacqueline Jolicoeur. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home and school, place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any of those items to the nearest police department. Follow receipt of the court. Do you understand the stay away order?
Yes.
Okay.
And Judge, I just wanted to add one thing. He has a family law case with the alleged victim in this case. I know we typically argue these motions.
Do they have children?
Yes, Your Honor. They have a 2-year-old son.
You want third party contact for exchange of the child or children for time sharing?
That's fine, Judge. He has a pending family law case in Broward that permits time sharing. He's the primary parent. I was just going to make a simple request if the court would consider perhaps the stay away order we don't have an issue with, but just deferring to the family law time sharing order that's in place right now.
Yeah, I'm gonna say all I'm saying third party contact is permitted for exchange of child. Is it one or two?
She's
or
here,
more?
the alleged victim is here.
Oh, the victim is here. Okay. Hello, where's she? I guess my word is going slow with that. Hello, ma'am. Raise your right hand to be sworn, please. Your other hand, please, your right hand. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
I do.
Okay, what is your name?
Jacqueline Jolliker.
Are you afraid of Mr. Alexander Rio?
Say it again?
Are you afraid of Mr. Alexander?
Yes.
Okay, you want to stay in order?
I do, but we also do have a 2-year-old son, and I'm supposed to be permitted 2 phone calls a day. So I agree to the no contact order as long as I'm still allowed to have FaceTime time sharing.
What I'm going to say
with
is
my son.
he can't answer the phone. Third-party contact is permitted for exchange of the child for time sharing. And you can defer, a court defers to any family court order.
And Judge,
regarding-
I believe the alleged victim resides out of state in the state of Massachusetts, so there won't be any exchange of the child because the child.
All right, so
I am permitted time sharing, so I can see my son.
well, what do you want me to put here for the time? He can provide. It won't be a violation of the court order for him to allow telephone contact with the child.
Yes.
Is that what you want to put?
Yes, please.
So, sir, you cannot speak with her regarding the child. Do not discuss anything other than answering the phone and give the phone to the child. Do you understand? Okay.
The child is 2 years old, so I'm not sure if somebody else should maybe facilitate the phone calls.
This is not family court. Go to family court if you have any issues. This is criminal court. It's an incident from 2 years ago. So I'm just dealing with this criminal matter. I'm not the family court judge. I'm allowing him to facilitate timeshare, telephone time sharing with you because you asked. Is that correct? Is that what you want?
Yes, it's just if he hands the phone to the toddler, I'm not sure I'll get my phone call in totality. So I'm just maybe he can prop up the phone or something and make sure that I get that time with him.
Can you make sure she gets the time?
We can do that, Judge. That's not an issue.
He has a good lawyer. Maybe he has any issues to the attorney if it's not getting done. Okay. Anyway, do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. And you must immediately surrender those items to the nearest police department. File that receipt with the court. And what do you want in terms of a bond that happened 2 years ago? It looks like these two have other issues. You want me
Yes,
to
Judge.
ask it for Ms. Davis?
Your Honor, we're asking for a nominal bond amount. I think
I'll set a bond at $2,000.
Okay.
You want a trial or you want a straight bond?
I guess a surety, Judge.
All right, $2,000 bond. I can give free trial services. He gets out of jail for free. You want that?
Okay, let's do
Want the
free trial
option?
services, Judge, the option.
Free trial alternate bond, $2,000. Ma'am, Ms. Joliker, thank you for coming in. If there's any issues, reach out to Ms. Davis if you're not getting your phone calls or your attorney for your family law case, or write a letter to the judge in your family law case. But he's allowed to only facilitate your child having contact with you, okay?
Thank you.
Thank you, everyone. Have a good day, Judge.
Good day, thank you.
So Great Granny in the chat is asking about the acoustics and the sound in this courtroom. So they actually spent a couple of months late last year doing technical upgrades in this courtroom, and the solution, the final outcome was the audio got worse. But we watch Judge Glazer because her anger level is proportionate to the closer she is to lunchtime. So as the morning As the morning ramps up, you'll see her get more and more angry, and she has interesting outbursts and stuff like that. But time to change it up. Let's move slightly north. We'll go to Georgia, Fulton County's all-purpose calendar. This is Judge Morrow.
A factual basis and venue. We just asked the court to follow the state's recommendation as a negotiated plea, Judge. And she did spend 17 days, so this turns out to be a time served sentence.
Okay. Ms. Nelson, it's my understanding that in case 25 CR 004044J, you wish to plead guilty to battery family violence, and in case 26 CR 000258J, you wish to plead guilty to simple battery family violence. Is that correct? You have to speak up for me.
Yes, Your Honor, correct.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor. Thank you.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right? Say it one more time for me.
Yes, Your Honor.
Has anyone forced you or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Ms. Nelson. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, ma'am.
Thank you, Your Honor. You have a blessed day.
You too, ma'am.
Number
53, Ms. Stanford.
Also a negotiated plea.
Yes, Judge, it is.
Good morning, Ms. Stanford. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can place your hand down. Ms. Evans Battle?
Yes, Your Honor. As to count one, it's 12 months probation, complete the Operation 21 law and decision-making class, complete 30 hours of community service, stay away from the location of Washington Park, which is at 102 Ollie Street in Atlanta. As to count two, 12 months probation, pay a fine in the amount of $300, stipulate to identity, venue, and a factual basis for the plea. Thank you, Your Honor.
Yes, Mr. Haddad?
Judge, we stipulate, ask the court to consider terminating probation upon completion of the requirements. I did want to mention she's not going to be released right away, Judge. She has a felony case that she's going to prelim, I think, next week, Judge.
Okay. Ms. Stanford, it's my understanding that in case 26 CR 000103Y, you wish to plead guilty to loitering and prowling and willful obstruction of law enforcement officers. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
Been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Stanford. When you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, ma'am.
Thank you.
Yes, ma'am.
We'll pass the baton to courtroom 2.
Okay.
We can go with positions 1 through 6. Mr. Benson.
Good morning, Ms. Rainford. This is going to be a negotiated plea.
Yes, Judge.
Good morning, Mr. Benson. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Good.
Thank you, Mr. Benford. You can place your hand down, sir. Ms. Evans Battle?
Yes, as to the case ending in 300C, count one, 12 months, serve 128 days, and we would commute to time served. As to count 2, 12 months, 120, serve 120 days, commute to time served. Count 3 would merge into count 1. In that particular case, stipulate to identity, venue, and a factual basis for the plea. As to count 302, it would be 12, case 302, 12 months, serve 120 days, commute to time serve as well in that particular case. As to the third case ending in 209G, count, it would be battery, 12 months, serve 120 days, credit for time served, balance probated, complete the family violence intervention program, no further contact with Starkeisha Laster, complete 40 hours of community service, and we would ask that the probation reporting continue throughout the term of that probationary period. I'm not sure that we get case 21 CR 005206G placed on the calendar.
That's willful obstruction of law enforcement officers?
Yes.
Okay, I have it on my calendar. Have you been able to discuss that with him, Ms. Rainford?
No, Your Honor, I did not discuss that with him, but I can briefly.
Okay, if you'll go ahead and do that, so that if these are all the charges that he have, we can take care of them all. And you're asking for a $300 fine on that? You
Yes,
said,
Your
Ms.
Honor.
Palmer? Okay. All right, so go ahead and mute yourself there, Ms. Rainford, and let me know when you're ready to proceed.
Okay, Great Granny, thank you for the $2 super chat. TCF never boring, always original content. Thank you. That's what we really strive for here. Original Daniels Nina says in the chat that this is the first time TCF has come up in my courtroom feed. I'm seeing judges I haven't ran across before. That's kind of what we try to do here, is show court from around the country, be able to see different things, experience different things. Some of it's cool. Every now and then we run across a dud. You just never know. Every day is different. But the idea here is to learn, to discover, to have fun. And as a bonus, you get to interact with, quite honestly, one of the best communities, if not the best in LawTube. The people here are wonderful. So stick around. You'll enjoy it. Let's change it up. Let's go to Michigan. Judge Mom, Elizabeth DeSanto.
All right, so let's go on the record in the matter of the Andrela Hager, 22991. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke here on behalf of Ms. Hager. I'm in the wrong thing.
No, sir, you're right where you're supposed to be. It's just going to be a little bit before your hearing. Okay, and so ma'am, your name for the record, please.
Andrela Hager.
Okay, thank you. Today is the date scheduled for probation violation. Ms. Hager is on probation for attempt retail fraud. And it's alleged that she failed to appear for probation visits on November 9th of 2022 and November 29th of 2022. And counsel?
Yes, Your Honor, I had a review of the documentation that was sent to me. It indicates that, yes, she missed these 2 dates. I gave her the notion of what she was able to do regarding a hearing to contest whether or not she was there on those dates and time. That will not be necessary. She'll admit that she failed to appear at those probation visits, Your Honor.
Okay, and so ma'am, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth? Okay, I need you to speak up a little bit more loudly, please.
Yeah.
Perfect, thank you. I'm recording on my device here, so that's okay. And so ma'am, you did hear, you may lower your hand. You did hear the allegations that were stated on the record, correct?
Yes.
As to the allegations, ma'am, how do you plead? And you've gone over your advice of rights for probation violation purposes, correct?
Yeah,
And you understand all of those rights.
yes, he was saying like, pay the, balance over $1,000 and then, continue the probation. Is that correct?
Well, no, first I want you to understand that your various rights that you have for probation violation hearing.
Yes,
And that by entering into a plea that you're going to be waiving some of those rights.
yes,
And you've gone over those rights with your attorney.
yes,
Okay. You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
yes,
And you understand the recommendation in this matter is for probation to be revoked, under advisement status to be revoked, probation violation fee, and it says 15 days jail. Do you understand that?
yes,
And as well as paying the balance in full. And knowing all that, do you want to continue with your plea?
yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? Any immigration issues?
No, Your Honor.
All right, counsel, if you can please voir dire your client.
Yes, I'd like to direct your attention to the dates of November 9th, 2022, and the dates of November 29th, 2022. Do you stipulate that you did not appear to probation visits as previously ordered by the court?
Correct,
You need to speak up, please.
correct.
Okay.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate, and the court will accept your plea to the probation violation, indicate technical violations 1 and 2 will enter based upon your plea, and counsel as to the recommendation.
Your Honor, my client indicated that she was unaware for whatever reason that this was still an outstanding issue, but she is now gainfully employed. She works at UPS. She's a package handler. She lives in Detroit with her mother. She's not on probation or parole. She's 27 years old. I know it's a little bit older of a case, but I'd ask that she be given an opportunity for a review to see if she can get this balance outstanding and potentially find herself in a more advantageous position. Obviously, with the balance, I think that sending her to jail at this time would potentially lengthen the amount of time that she could get this balance zeroed out. So I'd ask for a delay of any aggressive admonishment at this time, Your Honor.
So ma'am, why didn't you appear over the last 3 years?
At the time, they told me that they had, a miscommunication with the case that they put retail fraud when it was attempt retail fraud, and they never made a adjustment on the case. I don't know what that was about, but it was attempt retail fraud, not retail fraud.
No, right. So, but I don't understand how that affects you appearing for your probation
No,
appointment.
I'm saying, like, why would I go to probation if there's like, I'm going to go to probation for something that's not accurate on my.
Because you were ordered to participate in probation.
I'm saying, but it's not accurate.
Okay, so what did you do to try to correct it or bring it to?
Probation officer and ask him to switch it and fix the thing that was on the, the paperwork, and he never fixed it.
And how do you know that was never fixed, ma'am?
I looked on the case online. And never said attempt retail fraud, it just says retail fraud, it never said attempt retail fraud.
Okay. And so, ma'am, so then you thought it was the best practice to just ignore it?
Not ignore it, like I said, I fought numerous times, never got a call back.
Did you come up here?
No, I didn't come up here, I just gave the call back.
Right, so if it was that important to you, ma'am, why didn't you come up to the court?
This is my first time coming to the court, I never knew I had.
And I'm not sure what you're looking at because I'm showing attempt. I'm showing right on your criminal history, ma'am. It's showing attempt.
Well, that didn't say that in the, online.
So
Online said retail fraud, it never said attempt, when they sent me the link, when I just tried to do a background check, it never said attempt retail fraud, it said retail fraud, so.
well, I'm looking right
That's
at
the
it.
only reason I'm up here, because I had did a job and then the background check like popped up for me to do a background check, and it said retail fraud, not attempt retail.
Well, that's interesting because it's also suppressed because of the HIDA status. So I have no idea what it is you're looking at or not looking at. But in any event, you took 3.5 years or 3 years to take care of this.
That's what I'm saying, it's inaccurate, like when they were nothing being stolen or anything, so I'm just trying to see how can we proceed in a proper manner. I know the attorney said, hey, let's find and then probation.
Well, the recommendation is for probation to be revoked and under advisement to be revoked because you didn't do anything that you were ordered to do, ma'am.
That's what I'm saying. He said just pay the fine and then probation. Correct?
That's not how that works. Just pay the fine and then probation. The recommendation is to revoke probation. You didn't participate in your economic crime program. You didn't participate in your random testing. You didn't participate in workforce. One of the conditions was random testing, ma'am. And you didn't, did you resolve your outstanding, did you resolve your outstanding warrants?
I'm working on that as well.
Okay.
Go through the list of warrants I have, they have been.
So in July of 22 is when this court sentenced you to those conditions, and you didn't do any of those. Sorry, it was August 15th of 2022.
They like numerous tickets off. You talking about like civil warrants, like driving?
Ma'am, all of the warrants, you had 6 warrants for your arrest.
And I've been paying all of my tickets off. If you go through my civil warrants of driving, I've been paying for numerous warrants off, over $3,000.
Okay.
Over.
And that's good, ma'am. But this court ordered you to participate in probation and you didn't do anything. You didn't appear at probation appointments.
Right.
You didn't do anything. So, counsel, why should this court not revoke the under advisement status and not revoke probation and allow your client to continue when she didn't do anything in the last 3 years?
Your Honor, I'd only ask you to consider that she does have a strong caliber job, and I think that, there was a little ambiguity there. I wish that obviously we could go back in time to get this solidified in a different manner, but she's still in a position where she can clear her balance with the court, I believe, in a relatively efficient manner, and I'm concerned that if it were just to be revoked immediately or put into jail, progress that she's made would be halted. So I'd ask that she be just given a review date on this particular matter to see what sort of progress she makes, because obviously the admonishment of jail or probation being revoked can be implemented at any time. I'd ask that she be given one final opportunity to demonstrate full compliance with this honorable court. Thank you, Judge.
Can I speak?
What's that, ma'am?
I said, can I speak?
What's that?
Like I said, I have been paying over numerous amounts of tickets that like a lot of numerous of my money has gone to. Like I said, my license has been suspended for time, maybe over 5 years. I'm putting like a lot of money towards that. So you can pull it up into the system. It's been Southfield, Lonia. Like I said, I might have ignored this situation, which I could have did, multitasking, did multiple things, but it's only so much I can do with just working at EPS.
I understand as far as the payments, right? You have limited income. However, you didn't do anything with probation with this court. Because you had some information that it was the incorrect plea or charge that was on your record. So instead of coming up and meeting, had you met with your probation officer on those 2 dates, you could have addressed that.
I told you that.
But
it was Zoom. It was like
either way, you didn't show up November 9th of 22. You didn't show up November 29th of 22. Here's what I'm going to do, ma'am. You're getting one chance.
Okay.
That is it.
Okay.
The court's going to order your probation to be reinstated or continue probation. $12 months. Complete all terms previously ordered. $15 days jail. Suspended. Will continue your under advisement status, which will be revoked if any violation.
The 15 days, you said, so I have to do 15 days?
I suspended it, ma'am. If there's a violation, you'll be doing those 15 days.
Okay.
Okay. Stop at probation. Somebody will be with you shortly, and we'll go over all of your terms and conditions that were previously ordered. We're going to require you to do all those. Have a good day.
Thank you, Judge.
So I was curious about this because the jail for her was suspended. So I was curious if there's like an overcrowding situation or something like that, because we've seen that before where the judges are encouraged to not put people in jail if they can avoid it. But current Wayne County stats, this is as of today because their department has a dashboard. Their inmate population is at 1339, which is a lot of people in jail to be sure, but the jail holds about 2,600. So it's not a population problem. They're only at about half capacity. So, but they could have a staffing situation or something like that where they don't have the officers to care for the people. I'm curious if there's something going on there where they're encouraged not to jail people unless they absolutely have to. It's a question. Anywho, let's change it up. Texas, Judge West.
Yes, Your Honor.
You have all his reports, please. Jail reports. All right, are you Aleem St. Clair?
Yeah.
And Mr. West, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Mr. St. Clair, in cause number 23, DCCR 2044, you're charged with the first-degree felony offense of aggravated robbery, and that's from August 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? And then in cause number 23, DCCR 2117, you're also charged with the first-degree felony offense of aggravated robbery from August 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. West?
Oh, this one we want in.
The ones on the tablet?
Oh, yes, ma'am.
And did you, and do you understand what you signed, those documents?
When you told me, yes, ma'am.
Okay, and do you understand if I follow the agreement that you made with the district attorney, that you're waiving or giving up any right to appeal? So you can't change your mind if I follow these agreements later and say, I don't want to take these deals. Do you understand?
You say you want to take the deal?
If I follow this agreement and I give you the 10-year deferred probations and all of that, you can't later say, I want to change my mind.
Oh, yes, ma'am.
Okay. And it looks like the agreements that you've reached with the district attorney's office is a 10-year deferred probation in each of those cases. There would be a $1,000 fine in each case. There would be dismissals as part of this and cause numbers 23 DCCR 1390 and 23 DCCR 2043. There would be no contact with the victim. Any additional conditions included after we get a pre-sentence report, which could definitely include some type of treatment, ISF or something like that. Do you understand?
Yes, ma'am.
Do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection?
It's admitted in each case. Is there any evidence that Mr. St. Clair is not competent?
No, yeah.
All right.
I'm sorry.
Sure.
If I may, just so Mr. St. Clair understands, typically we don't write that in a plea paper. What my intention was, and what Mr. West and I had discussed based on his very young age, was to be able to include everything that we could to help him at this stage of the game before he gets himself into courtroom. So that was our intention in including that. Those things are meant to help you.
Yes, ma'am.
Thank you, Ms. Malfino.
Thank you.
So states 1 is admitted in each case, and there's no evidence that he's not competent, correct? So, Mr. St. Clair, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your pleas.
Yes, ma'am.
Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do that pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing.
Can I get a PSI bond?
You cannot get a PSI bond. I have 34 pages now of jail incident reports. When you come back for sentencing, if I go along with this agreement, it will require, I'm telling everybody right now, you will go to ISF, okay? And that's meant to give you tools to be more successful. But I don't know, you've been in there long enough. I think you've probably seen 2 that were given ISF, and a condition of their bond, a condition of their probation was not to get any jail incident reports. And they never made it to ISF, and I revoked their probations. And I'm telling you now, I will do that. If you continue to act like an absolute heathen at our jail and treat everybody, including the correctional officers, other inmates, like you have been, you're never going to see the light of day again for a long, long time. These are aggravated robberies. They're first-degree felonies. If you violate your probation, I can give you the rest of your life in prison. Minimum 5 years in prison, up to 99 years or the rest of your life. And I don't know if you can tell, but I hope you can, how serious I am, that this isn't going to be some little 5-year, oh, he was just acting up in the jail kind of thing and he's young. If you can't follow the rules, then you're not going to get these deals and you're going to end up in prison for a very, very long time. So it's time to straighten up. I don't care what everybody else is doing in the jail. You need to go in and say, I want this deal. I want to get out. I want a real life. I want a family. I want to work and just have a normal life. I'm going to sit in my bunk when I'm supposed to. I'm going to dress like I'm supposed to. I'm going to do what I'm supposed to, You don't get to make the rules when you're there. You get out, you're on probation, you have some freedom, right? You don't have that freedom in there. Prove to me between now and sentencing that you can do it. Okay, go back with the bailiff.
Thank you. Have a good day.
Thank you, Your Honor. Maybe excuse me.
Yes, sir, thank you.
Do you need any more?
No.
You're free to go.
Thank you, Judge.
Mr. Burbank, you have Desarian Adams. Are there witnesses or just?
I have Mom if you need it.
Okay, I'll let you just proffer what she would say unless I need some specific information. You have Good morning.
Good morning. Poor judge, poor whatever.
Good morning. Are you Desarian Adams? And this is cause numbers 23 DCCR 0492 and 0493. Mr. Adams is on probation in each of those cases for the third-degree felony offense of deadly conduct discharging a firearm. Was placed on probation September 26th of 2023. Looks like the allegations in those motions are an alleged new offense of fleeing from a police officer in December of 2025, unlawful carrying a weapon December of 2025, failing to associate with disreputable persons or be present at a location where criminal act was committed, failing to report the arrest, failing to perform community service, out past curfew, possessing a firearm in violation of probation, behind in fees in both cases. Mr. Burbank has filed a motion asking that I set a bond in each of the cases. He's on deferred probation, and at this time there's no bond. Is that correct? Mr. Burbank, you may, Mr. Adams, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Mr. Burbank, you may proceed.
Right, just for, if I may, just make a brief statement.
Sure.
These two offenses are.
I need everybody to hold it down. I need you to speak up a little, please. Thank you.
These two offenses are misdemeanors. I have talked numerous times to the district attorney. He has cooperated and as much as he can. We do not have the actual police reports except the PC. I don't know if you have a PC or not.
I don't, that's what I was
Judge,
looking
I was going to
for.
tender the copy of the probable cause affidavit to the court for this. You can tender it. I marked the state's exhibit 1, Your Honor.
No, any objection to states one?
Oh, no,
Thank you.
One of the things that we are lacking is the video of the scene because I read it as a defense attorney, kind of have questions and rules to the charge itself. The firearms being in the back seat, there were other people in the car, and the firearms were next to them. No one claimed ownership, but basically because he was the operator of the car, he was arrested. I will also submit to you that he was probably the only one that was not intoxicated at the time, and as such, it was not his car, and he had to get home, and so he was the designated driver at the time. And so with that, Judge, the other thing too I want to point out is I've asked Mr. Adams, I believe that he has no write-ups in the jail since he's been incarcerated in reference to any disciplinary actions. And I would like to call Mr. Adams.
Go ahead.
For the name, for the record, state your name. And what I have told the court in reference to your behavior in jail, have you been acting accordingly?
Yes, sir.
And you have not had any write-ups?
No, sir.
How long have you been incarcerated? How long have you been in jail?
18 days.
18 days? Yes. Now, you realize that one of the violations is you haven't been doing your community service fully, correct?
Yes, sir.
Have you addressed that problem since you've been incarcerated?
Yes, sir. I connected with my preacher.
Speak up.
I connected with my preacher. And he's one of who.
Who is your preacher?
Jeremy Williams.
Okay, and he has a church on Washington Boulevard?
Yes, sir.
And he has advised or has told you and your family that he would make sure that you got on the right track and did what you needed to do, correct?
Yes, sir.
In addition, your mom's back here, correct? You may not have known that, but she's here, right?
Yes, sir.
You realize that you shouldn't have been where you were, correct?
Yes, sir.
And you shouldn't have been in a car with firearms, correct?
Yes, sir.
Though we do have affidavits from the people there claiming ownership, we haven't gotten to that point. They were not your firearms?
No, sir.
Okay. If the court was to consider to post a bond, do you have any problem living with your mom or having a monitor on? or any other type of monitor to whether drugs or alcohol or anything like that, correct?
No, sir.
And abide and try to get back on track again.
Yes, sir.
You do not have any assets in reference to bank accounts or anything like that, correct? And though I am here, this money came from family members, correct?
Yes, sir.
You don't have anything to post, well, you'd have enough to post a reasonable bond, if one was, set, correct?
Yes, sir.
I have nothing further, Judge, unless you may have some questions in reference.
Give me just a second. Thank you.
One last, do you have a job?
No, sir.
Can you get a job?
Yes, sir.
When was your last job?
Construction site in August.
In August? So what were you doing on the construction site?
Flagging.
Flagging?
Yes, sir.
You think you can get that job back?
I'm actually getting my CDL. Ms. Joseph hooked me up with the school that I've been getting to, and I'm on my last step of getting my CDL.
So you were enrolled in school at the time that this happened?
Yes, sir.
And you only have one more stage in order to get your CDL license?
Yes, sir.
Mr. Nichols?
Judge, my concern is this. He's on two probations for being involved in a shooting, 2 deadly conducts. It was a situation where shots were exchanged between 2 different groups of people, and he was on one side of that. And obviously, there wasn't much cooperation from either side, so he ended up with 2 deadly conduct probations. Here we have him in a car with 2 other guys, 3 people, 3 guns. And the reason, once the officer tries to pull them over, they slow roll for a few more blocks. That's why it's eluding and not, or fleeing a police officer and not evading in a motor vehicle. And of course, during that time, all 3 guns are hidden under a jacket in the back seat. I don't think that's a coincidence that we have a delayed pulling over, and then 3 guns are in the back seat. What I don't have is a full case report of all the details, but we can tell that from the probable cause affidavit. I believe the individual he was with is Xavier Kane. Now, if it's not in that probable cause affidavit, then I'm mistaken, because that's the only information I have. If it is Xavier Kane, he's also on felony probation. He shouldn't be hanging out with him. The information.
Who was in the car with you?
Lyndon LaSalle.
Who's also a felon.
Okay.
This is
Lyndon LaSalle?
Junior.
Junior?
I looked this up for Mr. Burbank the other day. There is a Lyndon LaSalle Senior who's a felon. Lyndon LaSalle Jr., I dismissed a unlawful possession of a firearm by a felon case several years ago. That's why I recall his name.
Okay.
He's certainly a person of ill repute.
So he's a prior felon.
He may not be. I think he had a felon. He had a felon, a prior felony.
Okay, but not on anything right
That's not the
now.
reason for that dismissal. Nothing current. I don't believe he has a record, Judge.
Who was the other person that was in the car?
Jordan Collins.
Okay. It didn't matter to me, honestly, at this point, didn't matter. Okay, what else? Anything else?
Just if the court's going to set a bond, I ask it to be a high enough bond to protect the community. This is his 3rd case involving firearms, Judge.
Yeah, so Mr. Adams, the deadly conducts aren't just, it was a shootout between, it's just more of the same. Hang on, right now is probably not a good time for you to say anything, like Mr. Burbank. So the first case, or the 2 cases that you're on probation for, 2 people actually got shot. So you and whoever are shooting at each other, you admitted to the police officers that day. So there's no, I didn't do it. You admitted to it, you pled guilty to it, and 2 people got shot, whether it was your bullets or whoever else was shooting. Y'all were all shooting at each other because your grandma's car got shot up. So obviously y'all were getting shot at, y'all were shooting at people, and people who had nothing to do with it ended up getting shot, and you got deferred probation. I sent you to ISF, right? So you've already been to ISF so that you could get right, get the tools to make better decisions. And here you are out at 11:30 at night with 3 guns in the car, smelling like marijuana, cruising around doing what when you're supposed to be at home? With 3 guns in the car.
We actually was leaving the party. I never was in the car. I just
Should you
drove.
have been at the party?
I stayed past my birthday.
Okay. So it's hard for me to believe when you're out at a party and you're on 2 felony probations for 2 people getting shot, that you just ended up in some car. Why didn't you pull over? I'm not asking you to answer right now, but you didn't pull over when they asked you to. When they got behind you, you kept going. So at this time, I'm going to find all right, I'll grant the motions, but I'm setting the bonds in each of the cases at $200,000. A condition of those bonds, if you make them, is that you will be required, and I thought at some point, I thought I put you on house arrest, but I guess you weren't on house arrest at the time of this? Or were you supposed to be on house arrest?
I had paid everything off.
Okay, so you will be, if you make the bonds of $200,000 in each case, then conditions of those bonds are that you have to wear a GPS monitoring device and you will be on house arrest. You cannot leave your house except to come to court or visit with Mr. Burbank without my permission. Do you understand? All right, go back with the bailiff.
We can set this up.
You're watching TCF Live. Happy Tuesday. Good to have you all here. For the new people that are out there, and I know there's a couple of you this morning, I would call your attention to the show that we do Tuesdays and Thursday evenings here. It's called Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. So you get one of those tonight. And this is a community-based show. It was actually thought up by our community members, our channel members. We have some regulars on the panel that are here with you in the chat this morning, and we talk out different topics and whatnot. So be sure to join us for that right here on this channel tonight. I'd also call your attention to In the Blind with Mike and Dan, which is a news show that Michael Groff and I are doing. Since there was some confusion about this yesterday, I want to stress it is not a TCF show. It is its separate thing on a separate channel. Barbara has put a link out there in the chat, so you can check that out. Please do go over there and support us. It's a lot of fun. The thing there is Mike and I have no idea what we're going to talk about until we actually start the show, so it's a lot of fun. Let's go back to Judge West.
-14477 and then 19-32216. Previously in court, pled true to counts, looks like 1 through 6 or 7. The numbers are kind of, pled true to failing to report, failing to appear in court for judicial review, failing to maintain employment, failing to pay, and fail to complete anger management. In each of those cases, I've received an updated report. Has everyone received that report?
We have.
Are there any additions or corrections in that report?
Judge, only addition, if I may, with the court, obviously we understand it's your decision. I have spoken at length with Mr. Burbank about it, spoken at length with Ms. Robinson about it. Obviously, the court will see the age of these cases, especially the one that's from 2000.
Well, they're both only being held, I only have one
Correct.
choice, right?
Right.
Revocation.
Right.
I can't extend or
No, and
continue.
that's not what we were asking.
Okay.
We were proposing based on the age of everything, and I believe Mr. Burbank has some testimony to offer with respect to the fact that she was gainfully employed at all times. She admits that she didn't report. I think she's obviously had the problems on probation, but due to the fact that what frustrates me is that she's never been in trouble and she's going to become a convicted felon real quick. She's spent a considerable amount of time on these MTRPs over the holidays, et cetera, and we have all discussed asking the court to possibly consider allowing that and maybe a little bit of additional time if you feel necessary to serve as a sanction and just allow her probations to expire out without giving her the convictions due to the fact that these were not aggravated offenses and the age of them is obviously up to you, but that's just something we have
I also have, for the record, Mr. Burbank's office sent over several letters yesterday, one from Ms. Williams that I've read. And so, Ms. Robinson, you're here today. Thank you for being here. Had some positive things to say as well in the updated pre-sentence report. What are your thoughts on that proposal, Ms. Robinson? You do?
If I could fill in just a little bit.
Sure.
I think she's worked at every restaurant during this period of time. She's worked at McDonald's, she's worked at Cracker Barrel, she's worked everywhere. Whataburger, she has 5 kids, right?
Yeah, 5.
5 kids. She was currently and still, we reached out to Black Bear Diner before she was picked up for this incident. She accepted a kind of a promotion to be a manager there. So she's worked her way up from working there to manager position. And my understanding is that it's probably still available. Her mom is here too, and she would just testify. We have attempted to try to verify the W-2s, but because she's been in here, we've done the best we can in reference that she has been employed, and we provided everything to the state. And I would ask that you consider all that in the decision.
Well, Ms. Williams, I really appreciate your letter more than some that I get, because it really did seem very sincere. And I appreciate that you have come to realize kind of what started all of this back at 15, 16, right? And so that self-realization is big. It's taken a while, but it's big. And so a lot of times I get letters and I can tell someone else probably wrote them, or it was not from the heart. And I appreciate your letter, and I appreciate what everyone's saying here today. And based on all that, I will allow the dismissals of the motions to revoke. I'll sign those when it comes through. Do better for you and your kids, so that you're not back in here on anything else, okay? All right, good luck. Yes, ma'am. Yes, sir, thank you.
All right, friends, let's stay in Texas, but let's go over to Judge Boyd. Say good morning to her.
They're called Flago.
Oh, what are Flagos?
They are not fashionable, I'm gonna tell you that right now. But I got the matching set. So I got the pants and I got the top.
Mm-hmm.
I wore those out in the 18-degree weather. I didn't feel a thing for 20 minutes.
Wow.
I didn't feel a thing until my feet got cold. Like those things, we wore those during the freeze. We didn't feel a thing. I could have turned off the entire heating system.
To get that for my brothers.
I'm telling you.
Okay.
Again, not fashionable.
Well, I'm here for the warmth. I'm not here for the fashion.
I'm making this company famous because it worked.
Oh,
And
wow.
I'm easily cold. I'll wear 5 layers if I need to.
Mhm.
I almost came to court in these.
Okay, to get that. All right, so we're here on discovery issues.
There's the discovery issues, Judge. And I spoke to state. The prosecutor that is on the case is having car issues. She's not here. But the phone dump that was talked about last setting has not been produced to defense. That's something we're still waiting on.
All right, so is that the only thing?
Nope. We also have a motion to withdraw, Judge.
Okay. So could I see them? Well, before we do the phone records thing, let's take up the motion to withdraw. Do you have?
It was filed and accepted, Judge. It was done so before I got here, so I printed out a copy anyways.
All right. There's my stapler. Well, I will tell you in the back office, the electricity is out.
I heard.
So, do you mind if I keep this for the court and they can file stamp it?
Yes, Judge.
All right. Have you had a chance to, before we go on the record, have you had a chance to review the motion to withdraw?
I sent him a copy, Judge. I talked to his mother about it on Thursday of last week.
Could you talk to him about it?
I did talk to him about it as well, yes.
Okay, so you understand the motion to withdraw? All right, the court is calling 2025 CR 012576, State versus Jacob Leal. Can I have parties announced for the record for the state,
Pertaining to the state of Texas.
for the defense?
John Pettis for defense.
And are you Mr. Leal? All right, your attorney has filed a motion to withdraw. And before I ask you a couple of questions, State, do you have any objections to the motion to withdraw? All right, State, you may be excused. So, Mr. Leal, I'll just have a couple of questions for you, and it's not about the substance of the case, it's just about this motion. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Yeah.
All right, Mr. Leal, your attorney has filed a motion to withdraw. Have you had a chance to discuss the motion to withdraw with your attorney? And do you understand your attorney's reasons for wanting to withdraw? One of the reasons your attorney has in here is related to your contract with the attorney. I don't know what your contract is with him or not, because this is not civil, but that's one of the reasons why he wants to withdraw from your case. Do you have any objections to your attorney withdrawing?
No.
All right, then the court will grant the motion to withdraw. Counsel, you're excused. But counsel, when he's given a new attorney, whatever discovery you have, if you'll make sure that that attorney receives it.
Absolutely, Judge.
All right, you may be excused. Mr. Leal, are you going to be able to afford to hire an attorney, or would you like one appointed?
I'm gonna work on getting a court appointment. I mean, I'm working on getting an attorney, but right now, if I could like just get a court appointment.
Okay.
And I was remember like I'm on house arrest.
So here's the thing, that will need to be addressed with whoever your new attorney is going to be. So do you want one appointed, or do you want?
It's my okay one.
Okay, just have a seat. We'll make sure that you get an attorney, okay? Thank you.
All right, that one was short and sweet. Let's go back to Judge West.
Morning, sir. You're Robert Trahan. And Mr. Trahan has three cases, 25 DCCR 1094, 1317, and 1536. Mr. Eckhart, sounds like you have been working on the case but need a little more time. Is that correct?
I do, Judge. I have discovery, I have media, but I'm still going through everything to try and see if there's something that can work out with Mr. Coleman.
Okay.
I think by the next setting, we will be able to tell the court what direction all this is headed.
Okay. Any issues?
No, Judge, this thing's not closed.
All right. I'm just going to reset your case. When we're reset, Mr. Eckhart will be out there to visit with you about everything he has, and we'll see if we can get an announcement at the next court date. All right. You can go back with the bailiff. See, Mr. Nope. Mr. Parker, you have Jason Jones.
He's one to request hearings. I guess we just go through the motion.
Okay, thanks. Good morning, sir. Are you Jason Jones? And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. And so, Mr. Jones, in cause number 23, DCCR 0390, I have a motion to revoke your community supervision. Shows that you were placed on probation June 2nd of 2025 for the third-degree felony offense of unlawful possession of a firearm by felon, and that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you were arrested for, state wish to do anything with that wording?
I would like to amend it to say.
Y'all gotta go through all
committed
these.
The offense of.
On counts 1 and 2?
Yes, Your Honor.
Any,
I have no objection, but also point out, I assume the date is wrong on number 3.
That's correct. It should read June. Count 3. This is filed July 3rd.
yeah, probably, I'll print it. I need y'all to go through all these motions for the arrested language and change those.
Kelly, do we have an idea when it started?
I'm sorry?
When it started?
She has no
reading the
idea.
rest? Okay.
The MTRPs say arrested for instead of, y'all's people write them, so I don't know when they started doing that, or who, if it changed up there, if somebody changed that did that.
Well, we're in third secretary office.
Okay.
You know, a little over a year, so yeah.
They need to, somebody needs to make it their job to go back through all of them. Maybe at least for that year. It seems like it's been an issue.
I think so.
Okay.
But what I'd like to amend, Your Honor, is take out was arrested for and put committed. So recommitted the offense of.
And that's on 1 and 2. Any objection to that change in counts 1 and 2?
No, Your Honor.
And then in count 3,
The date should be June 21st, 2025.
any objection to that amendment? All right, made those changes and grant all that. Okay, so count 1 in the motion alleges that you violated your probation by committing the offense of possession of a controlled substance June 21st of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 alleges that you committed the offense of possession of a controlled substance. So the first one is penalty group 1-1/1B. Count 2 is that you committed the offense of possession of a controlled substance, penalty group 2A. And is that true or not true? And then count 3 alleges that you possessed a drug, marijuana, synthetic marijuana, and crack cocaine on June 21st of 2025. And is that true or not true? And then count 4 alleges that you failed to stay away from locations considered high crime areas by being arrested by BPD on June 21st of 2025 in a high drug trafficking area with various illegal substances in your possession. Is that true or not true? All right, so what we'll do, I'll enter pleas of not true to counts 1 through 4. We will reset this for a hearing. How long would you anticipate? I'm assuming you'll need lab and,
Judge, the substances have been sent off to an independent lab to expedite testing that's currently in their possession being tested. I made that request early December, so I expect it to be back before we have a hearing.
okay, we'll reset it for a hearing. I'll get an updated pre-sentence report. And as soon as obviously you get any of that information, get it to Mr. Parker. We'll set it for maybe a day where we have a little longer than just an 11 o'clock. We'll set it where we have time for officers and whatever we need. Okay? All right, you can go back with the bailiff. Wow, isn't that crazy? It's just like...
Yeah.
Let's see, is Ms. Peraza here? Mr. Radford, you have Corey Flemings.
Yes, ma'am. I sit on the trial document.
Good morning.
Morning, Judge. How are you?
Good. How about you?
Warm.
The cold weather's.
I wish I could blame it on the cold. I'm blaming it on the old. Mr. Radford?
Coleman?
Good morning, sir. You're Corey Flemings?
Yes, ma'am.
And Mr. Flemings has 2 cases, 24 DCCR 2144 and 2145, set for trial to begin with jury selection next Monday. What is the announcement?
Judge, we're ready, subject to a ruling on my motion to quash the enhancement portion of the indictment.
State's ready to proceed.
I would ask which case Mr. Coleman intends to try first.
We intend to try the assault on the peace officer, Judge, and put on punishment evidence pursuant to our notice of extraneous offense of the injury to the disabled person.
And so the enhancement portion wouldn't change anything other than potential punishment.
Yes, ma'am. It would require you to declare a penal code statute unconstitutional.
Oh. That would be novel for me.
Yes, I figured it was. I have a case pending in the 9th right now with the same issue.
So hold on a second, let me look at the indictment. Is the enhancement alleged? Yeah, so it's alleged in the indictment, and so I would need to make that ruling prior to jury selection.
Yes,
so
ma'am.
that, well, we don't talk about punishment range in the jury selection. We'll talk about it. I'll get the case numbered. And then if it's numbered 1, we'll handle it either prior to or just after jury selection, because it won't change anything that you say in voir
I
dire.
think that if the punishment range is 25 to 99 and he is convicted and goes to the jury for punishment, I do believe I get to voir dire on the potential range of punishment.
And if he gets to voir dire on it, certainly the state would ask for reciprocity on that.
I don't have a problem with that.
Well, here's how I handled any enhancements on punishment and how I would intend to handle it is, I do not go into specifics or allow you guys to go into specifics. I will, in my part of talking to the jury, explain that there are different circumstances that could lead to higher punishments or lower punishments depending on the evidence that's presented. But getting into specific, especially priors, if I'm going to make some ruling potentially that they're not admissible or that we're not going to get to until punishment, we're not going to get into that on guilt innocence. We're not going to get into it on voir dire very specifically, other than if there's something, because if you allude to it too much, I think you're putting yourself and your defendant in a position where you're telling a jury up front that he has potential criminal history that could go into their decision-making in guilt innocence. So
Yes, ma'am.
we're not going into that. I'll say what I say, but as far as spending a lot of time on it, that's not going to be an issue during voir dire. I'm not going to allow it to be one, but I will make the ruling that day so that we know before we get started. If it's going to change anything about the status of trial, and if I deny it, y'all want to renegotiate, or if I grant it, then let me know that. If you think it'll change anything, then I can make that, we can get something done either later today or tomorrow. I'll take a look at it so that you know ahead of time, because I want to know that, if I deny the motion to quash, which it sounds like I likely am not going to find our penal code section unconstitutional. If that changes Mr. Fleming's position, y'all talk about that today, because I want to know that if there's going to be some type of negotiation and a plea, I want that done today.
Yes, ma'am.
Okay.
Court's information, regardless of how the court rules, the state's prepared and willing to proceed with trial.
Yeah, no, it's gonna be numbered, and we're running low on, the number 1 just pled this morning, and so it's likely this could go. So I want serious, talk to Mr. Fleming's. I've looked at the motion to quash. If y'all want to talk about it real quick, I can let you make your argument at this point.
I think we already talked about it.
I think we did. And so, I can go ahead at this point and deny that motion to quash that you filed. And so that way, we've talked about it. I've read the state's brief. We read what you filed, which had your information in it. And so that being done, y'all, if y'all want to talk, if that changes anything.
Yes, ma'am.
Okay, so do you want me to hold it while y'all visit?
I've got a meeting I've got to go to. I will visit with him, and then if it's going to be a plea, I will advise the court.
No, it's going to plea today.
Yes,
Y'all
ma'am.
need to talk now,
Yes,
or
ma'am.
before docket's over.
Yes, ma'am.
Okay, I'll hold it.
All right.
I don't see a, order on his motion.
All right, well, they rack up another contestant. Let's go back up to Michigan, see what's going on with Judge Mom.
Please.
Zoe DeAngelos.
Okay, moving forward, if you have to appear in court before, crop tops are not appropriate.
Not a crop top.
Well, I'm seeing your belly between your shirt and your jeans, so that's a crop top.
Not a crop top.
Well, it's a crop jacket.
Okay.
Council, today's the date scheduled for show cause. Well, there was a show cause that was scheduled for January 15th on your client's failure to pay any of her fines and costs on her matter, and she did not appear on January 12th, and so the court issued a warrant January 15th. And counsel, do you have an opportunity to speak to your client regarding her failure to pay $870 on her case?
Yes, Your Honor. In this circumstance, she's not going to contest that matter.
All right, and so we can do one of two things. If your client is prepared to pay some money today and enter into a continued payment plan, we can adjourn the show cause, or she can plead guilty and we can proceed.
Your Honor, my client indicates that she did in fact make an online payment on Sunday, January 25th. And then I know that potentially we were going to be seeking a payment plan that would be starting on or about the 2nd of every month. So I'd ask in the circumstance that there be an adjournment that would at least give the court an opportunity to verify that she did make a payment 2 days ago, and then I'd anticipate a secondary payment to be implemented before the next court proceeding.
How much did you pay on Sunday?
$50.
Okay, we're going to see it. We're going to recall this matter in a short bit. I'm going to see if that shows anything about posting, and then we'll recall this matter. Okay. So just have a seat for a few minutes. We're going to just double check on that. All right. And we are on the record in the matter of the City of Wyandotte versus Michaela Laux. 251613.
Good morning, Your Honor. Christopher Semke appearing on behalf of Michaela Laux.
And Ms. Laux, your name for the record.
Michaela Laux.
Today's the date scheduled for sentencing on your client's plea to an amended charge of operating while visibly impaired. The original charge of operating while intoxicated was dismissed by way of resolution between counsel. And counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor. It's factually accurate.
All right. And as to the recommendation, counsel.
Your Honor, as a recommendation, I believe that it is appropriate. The 12-month probation with the terms and conditions do seem that they would be very appropriate for the circumstances. She's not on probation or parole anywhere else. She's not accrued any other charges. I believe she'll be an excellent candidate for consideration for early termination. And then as to costs and fines, I would be potentially asking consideration for a payment plan. Thank you, Judge.
All right. And so, ma'am, if you were to test right now, what is in your system?
Nothing.
All right. Ma'am, your level is very high that evening. 0.201. Okay. And so why are you not working, ma'am?
I actually do have a job. I work at Olive Garden now.
Okay. Okay. And it says you're currently pregnant?
Yes.
When do you do?
August 1st.
All right. And so, ma'am, I presume that you stopped using marijuana?
Yes.
All right. When's the last time you used marijuana?
The day that I started probation.
Well, you're not on probation yet, ma'am.
Or the day that I started testing. I've been testing since I went into court.
Okay, and when did you find out you were pregnant, ma'am?
I found out the end of November.
Okay. All right, well, looks like the bond conditions were a good thing for you then.
Yeah.
All right, the court will note after hearing from counsel, hearing from Ms. Laux, in reviewing the report, the recommendation that there is reasonable grounds to depart from MCL 769.5. The court also finds that that the following sentence is in the best interest of justice, is reasonable proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Laux and the legislative guidelines. The court's going to order 12 months probation. You're eligible for early discharge, and I'll go over that shortly. You are not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to also order you to participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can have assistance in providing coping mechanisms so you can maintain sobriety, hopefully preventing this matter from happening again. The court's going to also have you participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition so you can further increase the understanding of the dangers of driving while under the influence and the consequences of such behavior. The court's going to also order you to participate 5 days on the court workforce. The rehabilitative goal for that condition is to help you further develop life skills and give back to the community. Any questions regarding those conditions?
No.
The court's going to order a $300 fine, $100 screening assessment fee, $600 supervision oversight fee, that's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that could be waived. $300 to cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, workforce is $200. It's 5 days at $40 a day for a total of $1,625. You did post a bond, so you can apply that, and then you can set up your payment plan with probation.
Okay.
All right. And as I did indicate, you are eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. All right.
Okay.
All right. Thank you. Have a good day.
You too. Thank you.
Thank you. All right. And then so please email into probation by 10:30, ma'am. All right. Counsel, if you can just message that to your client. I think she logged off as I was speaking.
Yes, Your Honor.
Thank you. And so we are recalling the matter of Zoe DeAngelis. 241045.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client.
And your name again, ma'am, please?
Zoe DeAngelis.
All right, so we do show here that you did pay $50. It shows up as yesterday, obviously, because Sunday we weren't here. And so what is your proposed payment plan, ma'am?
She was asking for a payment plan to begin on or about the 2nd of every month, starting with February 2nd, for $50, Your Honor.
Okay, the court will indicate $50 per month beginning February 2nd. We will adjourn this to a date. If you miss a payment, then we'll set this back up for show cause hearing.
Okay.
If you don't miss a payment, ma'am, then the show cause will be dismissed.
Okay.
Okay, you can stop at the window if you'd like, but you already know how to pay online, so you have that information. Okay? Thank you. Have a good day. All right, and then we are on the record in the matter of Huntington House Apartments versus Natalie Hammond, 2502284.
Good morning again, Attorney Carrie Zanon on behalf of plaintiff.
Actually, let's not. Those disputes are never that enjoyable. Let's go back to Judge West.
All right, so are you David Chapman?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here we are.
Mr. Let me get this pulled up. We're going on more than one count. Mr. Chapman, in cause number 23, DCCR 2228, you're charged with the state jail felony offense of unauthorized use of a vehicle from November 17th of 2023. That indictment alleges that you were previously convicted of the third-degree felony of harassment by a person in a correctional facility, June 10th of 2016. And then after that was final, you were convicted of the third-degree felony offense of assault on a public servant, October 28th of 2019, in two different cases on that day. Which, and how do you plead to that charge? How do you plead to the unauthorized use of a motor vehicle? And are those prior convictions true? Did you enter your plea of guilty and true to those prior convictions freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Chapman's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a motor vehicle. Find those prior convictions true. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Caden Fontanette. I know.
Check on my other time to ask for resets.
Okay. Let me sign this. So on Francisco Garza with Mr. Nichols.
He got crazy on this weekend with jail, so I'm getting.
We're gonna reset Mr. Garza, Francisco Garza, and then Robert Simon.
We got a new offer this morning. He wants to go over some more discovery before he makes a decision on that.
We're gonna also reset Mr. Simon, Ms. Malfino, for Mr. Rojas, so he can go out and go over a little more information with him. And then this is Mr. Coleman Fontanette. Good morning, sir. Are you Caden Fontanette? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Fontanette, in cause number 25, DCCR 1759, you're charged with the first-degree felony offense of aggravated robbery from October 10th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And it looks like there is no agreement in this case.
That's correct, Judge.
But y'all marked out one thing, but then signed it so the post-conviction waivers, y'all marked out. But on the admonishment, you put that it's a plea bargain and he has a right to appeal. So if it's unagreed, he has a right to appeal. So I'm going to need you guys to sign, you and the defendant to sign that bottom, please. Would you do me a huge favor and put this in the microwave for 30 seconds? Maybe even a minute. It's so cold in here, it's gonna cold. Thanks. So it looks like there's no agreement, which means you're leaving your punishment up to me. And that range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand? What'll happen is, if I go forward today, I'll go through this plea and then I'll reset your case for sentencing. The probation department will do a pre-sentence report. And then at sentencing, Mr. Coleman, Mr. Rojas can put on any information or evidence that they want. And then I'll make that decision. Do you understand? You have an absolute right to have a jury come in and determine two things. First, you could have them determine if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do? Do you want a jury or do you want me? Okay, so you're waiving your right to a jury, right? Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Fontanet is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. Like I said, we'll get that pre-sentence report done, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he'll present it to me on your behalf when we come back. Do either of you anticipate a long hearing or just a normal day? We should be fine. Okay, we'll see y'all back at sentencing. Mr. Fontanet, I don't know that we checked today or not. I just want to let you know something real quick. But for sentencings, we always get jail incident reports. So I don't know what you've been doing, hopefully nothing. But if you have been acting up and getting incident reports in our jail, it better stop today, because I'll look at all of them. And if there's reports, when you come back, it is very unlikely that you're going to get a whole lot of anything out of me as far as low end of the punishment range or probation or things like that if you can't follow the rules out there, okay? Okay, we'll see you back at sentencing.
Interesting that judge gave him that warning. I've not heard her do that before. I've heard her take it into account when she's seen reports, but not warn somebody ahead of time, hey, don't get reports. So interesting. Let's keep dancing around Texas. Go back to Judge Boyd.
You entered a plea bargain agreement with the state on December 4th. According to your plea, state is proceeding on count 2. Punishment is to be assessed at a cap of 6 years in the prison. There's a $1,000 fine. State is silent on your applications. And this is to run concurrent with 2025 CR 012977. I don't have that pause number. Does she have a motion to revoke as well or no?
No, she's not on probation.
The other name is under cable. Do you, I believe,
Oh.
re-indicted it. There's 2.
She was initially under cable due, and I think it was re-indicted under Sanchez, yes.
So.
And the 8828 was, should be indicted too.
No, the 2025 CR 012977, that's what y'all say it's running concurrently with. So is that a motion to revoke? What is that?
It's an outstanding.
All right, so is that a case she pled on? Why is that running concurrently?
Pleading both of them concurrently, Judge.
Ah, okay.
Same plea.
Oh, and so that's the one that is now the -02?
No. -02 is one, the other one is 012977. Two different cases. One of them is 2021, one's 2025.
All right, so in your plea bargain agreement, it says that this is running concurrently with 2025 CR 012977.
Right.
So what case is
Plea
that?
bargain should be under 2021 CR 8828-02.
So it says something else in the plea bargain agreement.
Your Honor's sake.
Thank you. Let me see. Well, that's listed as a case when I look it up.
I think both cases were in the second stage. I'm thinking.
Do y'all want to see the plea agreement? Yeah. I need this case number. I'm sorry?
That's right.
So what is it? What is that case related to? It's not the 2021 case.
Yeah, 2021 is the one that's going to run concurrent with this. Lead one is at 88-02.
No, but what I'm saying is we're off the record. In the plea bargain agreement, it has the 2025 case. So is that 25 case same as some other case?
The 2025 case is a drug case arising out of 7/31/2025, and that is to be concurrent with the DC 2021 CR 8828-02. Let's see, take a look at that right here. So she has two drug cases. We're on that.
It's two active drug cases.
Oh, okay. The paperwork got switched. That's what's wrong. That's okay. Yeah, that goes there. All right, I'm going to recall the case. The court is calling 2025 CR 012977 and 2021 CR 882802, State versus Mary Elizabeth Sanchez. Can I have parties announced?
Blood written out for the defense.
And are you Ms. Sanchez? All right, and cause number 2025 CR 012977. You entered a plea. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's $1,000 fine. This will run concurrent with 2021 CR 8828-02. And in cause number 2021 CR 8828-02, according to your plea bargain agreement, the state is proceeding on count 2. Punishment is to be assessed at a cap of 6 years in the prison. There's $1,000 fine, and this will run concurrently with 2025 CR 012977. Have both parties had a chance to review the PSI report and TAP evaluation?
We have, Your Honor.
Any objections?
No objection.
All right, defense, do you have any witnesses?
We do not have any witnesses. We have some documents to present to the court that we have previously shown to the state.
All right, you may proceed.
All right, Judge. We are asking for probation in this case. We prefer outpatient. She recognizes she needs some treatment. TAP agrees to that. They're recommending either SATF, I think, or outpatient. She's asking for the outpatient. She has no prior record. She has a history here of some drugs, not a heavy user, but some. I would note at one point in the PSI, it says that she, I think in the second case, she and her boyfriend were driving, making deliveries. She was delivering for Uber, I think, but not drug deliveries. Since she's been incarcerated, she understands she's got a problem. She and I have talked. She has a couple of problems. There's a drug issue there. She's had some problems making decisions. And frankly, she has an esteem problem over some bad decisions in the past. I can give you these one at a time and explain them. What I'd rather do is let you look at these. I would comment on one. There is a wing course there. She has not only taken that course, she is now a mentor in that course. Worked hard, which has been in the jail, to figure out, number one, trying to take care of the drug issue, but also trying to work on her esteem and her ability to make decisions herself. To be she is certified in medical billing and coding. There we go. So she's employable. She wasn't doing that before. Again, I think that part of that was her esteem issue. I think if we get her straightened out, she can be a very productive member of society. She has 3 children, they're all grown. So we ask that you give her a chance, probation, starting at least with outpatient treatment. Doesn't have a heavy drug use issue, but enough to lower her judgment.
I have a few questions. Any objections?
No objections.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, make sure you speak up so I can hear and the court reporter can hear.
Let's get a little closer to this.
So, your boyfriend, did he know that you had these drugs? That's either yes or no. All right, so it appears that he may not be a good person in your life if he is aware that you had these drugs. And from what I'm reading, it wasn't a small amount of drugs. So, were you using at that time?
Yes, ma'am.
And how much were you using?
I was already starting to break myself off, so honestly, I couldn't tell you a specific amount.
And so your children was Child Protective Services ever involved in your life before?
Yeah, but not because of me. It was where I was residing at the time when they were little. They had a CPS school, so they opened it on me. I completed my parenting class and my therapy class they required, and I was finished with that. They signed off.
All right, and did you regain custody of your children?
I never lost custody. They resided with me, and I had a
Family-based service?
Yeah.
All right, this is what I don't know if there's, I know you all are silent, no questions. Okay. And your boyfriend that you were in this relationship with, who all lived in the household?
His parents.
Okay. And when's the last time you had full employment?
I worked full-time or part-time?
Full-time.
Full-time, I worked at a doctor's office,
Doing what?
medical billing folks.
Okay. All right. I'm going to give you a choice. Sometimes I can give people choices, sometimes I can't. If I grant your application, there's going to be residential treatment. So the outpatient thing is out of the question. It's going to be residential. Or I can deny your application and I'll sentence you to 3 years in the prison. Which do you prefer? Okay. Do you need to discuss anything with your attorney? I'm sorry?
Yes.
All right, I'll help you discuss with her options and then just let me know.
All right.
Who's next?
All right, well, she discusses her options. Let's go back to Judge West.
Mark Anthony King. And so Mr. King is charged in cause number 25, DCCR 1063, 1064, and 1065 with aggravated sexual assault of a child. The bonds, it looks like, are they all set at $250,000? The bonds are currently all set at $250,000. Ms. Holmes has filed a motion asking for me to reduce those bonds. And just based on what you guys were just saying, it looks like offense dates were from 2018 and 2019. Mr. King was a juvenile at the time and has now been certified. when I say at the time of the offense as a juvenile, but certified to stand trial as an adult at this point, correct?
Yes.
We're all on the same page. Okay. Mr. Nichols, before we go too much into it, what is the state's position with regard to bond?
I don't have a huge objection to a reasonable bond, Your Honor. This case involves allegations with an 8-year-old girl, or 8-year-old at the time. It was a delayed discovery, delayed outcry. In all candor, I've had trouble getting in touch with her family. And so I don't know where this case is going to end up at this point.
Was there, what was the relationship with the
It's a
alleged? A cousin, okay. So, Mr. King, where will you be living if you make bond in your case?
With my sister.
With your sister? And what, do you know the address?
1489.
Is it Beaumont? Is it Port Arthur? Is she here?
No, because I talked to his mom.
It's in Beaumont.
It's in Beaumont. What's your sister's name?
Raven Wilson.
Raven Wilson? Okay. Does Raven have children? How many?
Five. We have
How old? That's going to be a problem.
You can't stay with your mom?
So here's the thing, based on the nature of these allegations, at least while your case is pending, if I reduce those bonds, you're not going to be around any children under the age of 18. So do you have another option of where to live? You'll have to ask your mom. Okay, so let's do this. I'm not opposed to reducing the bonds. But I need to know that there is a place where there are no children under the age of 18 with someone who's willing to make sure kind of that happens. We don't need to have a hearing necessarily. I'll make the conditions of that. I'll likely have a GPS monitoring device and understand that that's a financial issue. So I'll take that into consideration on the amounts and also what Mr. Nichols said about the complaining witness and some difficulty.
And we'll continue to do our job, Judge. It's just at this point, we haven't been able to make contact.
Okay. And is it the same complaining witness in all three?
There's 2 complaining witnesses in the three cases.
Okay, all right. And are they the same?
Same rough age.
Family.
Yeah, 2 of them
But
is the same person, they just had 2 different dates.
But the two complaining witnesses, what is their relationship to each other?
They are cousins.
They're also cousins.
Yes.
Everybody's cousins. Okay. All right. So, yeah, get me that information. If you'll just send an email, Ms. Holmes, to Mr. Nichols and I'll let y'all know together what the amount is and what the conditions are, as long as there's a place that is for sure with no children under the age of 18. Okay.
Thank you, Your Honor.
Thank you.
And per our normal arrangement here at TCF, we don't seek that stuff out, but we seem to step into it once or twice every single day. What is wrong with this world? Anywho, decision has been made. Back to Judge Boyd.
R 012977 and 2021 CR 882802, State versus Mary Elizabeth Sanchez. So, Ms. Sanchez, did you have an opportunity to confer with your attorney? All right, which do you prefer? Okay.
Just how I explained it, she doesn't understand. She thought you were offering her straight incarceration or incarceration with treatment.
Okay.
She wants probation.
Okay.
The treatment is fine.
All right. State, you may be excused. And would you prefer a conviction or deferred?
Deferred.
All right, we're proceeding in cause number 2025 CR 012977. This is the court's ruling. Court will sentence you to 6 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random use, proof of employment within 45 days of release, no employment as a home health care provider or with minors, bill visits 1 time per month until further notice. In custody, she's to remain in custody for transfer to SATF. And probation, we can do a referral to felony drug court. If she's accepted in felony drug court, then she can go to felony drug court. But she's to remain in custody for that evaluation. This will run concurrent with 2021 CR 8828-02, 300 hours of community service restitution. There'll be 1 hour deducted for every sober support meeting completed. There's to be no residing in households with minors. Probation, is there anything else with regards to that case? Is there anything else you need from the court in that cause number to help you be successful? Next, we're going to proceed in 2021 CR 8828-02. Court is going to sentence you to 6 years deferred adjudication. There's a $1,000 fine that will be probated. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. This will run concurrent with 2025 CR 012977. Field visits 1 time per month until further notice. In custody for transfer to SATF, and also a referral to felony drug court in custody. There's to be no residing in households with minors. $200 hours of community service restitution. 1 hour deducted for every completion of sober support meeting. Probation, is there anything else? Regular reporting, I'm so sorry. Regular reporting by Zoom or in person, and regular random UAs. Is there anything else you need from the court? All right, in each of those cause numbers, did you review documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? In each of the cause numbers, because I followed your plea bargaining agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, and counsel, I'm just trying to find the other application. I'm sorry, the other trial court certification for you. There we are. All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to the court and address it with me. Do you understand? Now, this is what I know. With drug addiction, you got to be honest with yourself. If you're not honest with yourself, you're not going to be successful. And one of the hardest things with drug addiction is being honest that you need help and there are issues. Do you understand? All right. Good luck to you, okay? You're welcome.
All right, Texas continues to be where all the fun is. Let's go right back to Judge West.
A week or two to come get anything that you want together for me on sentencing since it's a cap now?
Yeah, that week should be
Best
fine.
whatever's best for the court that week.
Okay, let's do that. So I'm just gonna, that way, and just remind me to look at that again for sentencing. We don't need anything updated. He's been in custody the whole time.
Right.
So let's just reset it a couple weeks at the most. And so, Mr. Lowe, I'm just gonna reset your sentence, your case. Let's go ahead and go through the pleas though today, and then we'll reset it for sentencing, but without an updated pre-sentence report. We'll do it that way. All right, give me just a second. And I've rejected it, so we've got to go through all of it again, so. And again, you're Robert Lowe. And Ms. Holmes, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
All right, let's see. We're going on
The first three.
First three, Judge.
60, 61, and 62. Okay, 60. So I know we've already done this, Mr. Lowe, but because I reject that first plea agreement, then we have to go through it all again, just like if we had not done it before, all right? So in cause number 19-32660, you're charged with a third-degree felony offense of possession of child pornography from June 4th of 2018, and how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? And then in cause number 19-32661, you're also charged with the third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? And again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? And then finally, in cause number 19-32662, you're charged with the third-degree felony offense of possession of child pornography from June 4th of 2018, and how do you plead to that charge? Sorry. And again, are you pleading guilty freely and voluntarily, and because you did what they've charged you with? In all three of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 6 years in prison, which means if I follow the agreement, I cannot give you more than 6 years. I could give you 6 years, I could give you less. It'll all depend on any other information that's brought to me and the information that I already have when we come back for sentencing. You have an absolute right to have a jury determine 2 things. The first is to determine if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me within that range of the cap. And is that what you want to do? Okay. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Lowe is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing just so that we can all get back up to speed on it. If there's any other information you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back. Also, it is part of the plea agreement. It looks like that the state is going to dismiss cause numbers 19-32663, 32664, and 32665 as part of that agreement. All right, we'll see you back at sentencing. You can go back with the bailiff. Yes, sir. It's still an option. Yes. You can get anything from 6 years down to 2 years. Probation is on the table, or you're legally entitled for me to consider that, yes. Okay, yes, sir. You can go back with the bailiff. See, Mr. Lewis, you have David Dartez.
Judge, on Dartez, we have an agreement on him, so I wasn't sure if I actually did the right paperwork. It's just to MTRP, so it could have just lined through that first page.
I'll mark through the first and actually the top of the second as well on MTRPs. I always mark through them if y'all don't.
I wrote MTRP.
That's perfect. Thank you. Good morning. Are you David Dartez?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He does, Judge.
Mr. Dartez, in cause number 22-39677, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 11th of 2022 for the offense of theft of property, a third-degree felony, and that was a 6-year deferred probation. Is that correct?
Yes,
The motion alleges that you violated your probation. Count 1 alleges that you failed to report to the State of Louisiana Community Supervision and Correctional Department March, April, May, June, July, and August of 2024. And is that true or not true?
yes, ma'am, it is true.
Okay. Count 2 alleges that you failed to report by mail or online to Jefferson County, Texas, October, November, and December of 2022, January through June of 2023, September of 2023, and then November and December of 2023, and then January through September of 2024. Is that true or not true?
Yes, ma'am, that's true.
Count 3 alleges that you provided a urine sample October 10th of 2024 that tested positive for marijuana. Is that true or not true?
Yes, ma'am, that's true.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Yes, ma'am, that's true.
Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
Yes, ma'am, that's true.
And then count 6 alleges that as of October 10th, 2024, you were $650 behind in your fees. Is that true or not true?
Yes, ma'am, that's true.
Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, ma'am.
And because those counts are true. All right, I have here on the tablet some documents that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue you on probation, likely extend, and order that you enter and successfully complete ISF. Which program? And probation's here. Thank you for being here, sir. Is this also what you believe would be appropriate for Mr. Dartez?
Yes, Judge.
Okay. And so is that your understanding of the agreement?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted any evidence that Mr. Dartez is not competent.
No, Judge.
Any reason not to go forward today? All right, Mr. Dartez, it looks like everybody is willing to work with you and give you a chance to be successful on this probation. The number 1 thing is you got to show up. You've got to do your reporting online and in person. It looks like you tested positive for marijuana one time, which is obviously we don't want you doing, but we don't know what you're doing if you're not showing up. So in my opinion, you probably were doing that a whole lot more and just not showing up. If you continue to violate and not show up in person, not show up online, test positive again, and you're back in court on a motion to revoke, it's not going to go this smoothly. Do you understand?
Yes, ma'am.
So I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. I'm going to extend your probation by 2 years. You didn't show up for a while, so you're going to get more probation. In order that you enter and successfully complete the ISF cognitive track. And then it sounds like some type of aftercare, substance abuse, depending on where he is, would be appropriate. So If he's back here for some reason, JCDI. If not, and he ends up back in Louisiana, some program like that for any type of drug issues. So I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. All right, take advantage of this. All right, good luck to you. You can go back with the bailiff.
So there will not be a fourth hour today. I have matters I need to tend to between the two shows, between this and sidebar. But we'll go back to Judge Boyd's court for one last hearing for the day.
Plea into each one of these cause numbers. In the cause number 2025 CR 011020, according to your plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine. There's no application for community supervision. The state is opposed to your deferred adjudication, and this is to run concurrent. All right, off the record, we appear that we're missing some cause numbers for me. So this is running concurrent with 2024 CR 007176. Was that a motion to revoke or something?
7176.
All right, and has that already been taken care of or no?
He entered a plea of trip.
And then we have 2025 CR 011020. That's this case.
Right.
And then 2025 CR 011309A. And okay. All right, I see where we are now.
Okay.
Thank you. All right, so we're back on the record. And then in cause number 2025 CR 011311C, according to your plea bargain agreement in that cause, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. All cases are running concurrently. And then the state is taking in consideration 2025 CR 011310C and 2025 CC 009777. And in the cause number 2025 CR 011309A, according to your plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. All cases will run concurrently, and the previously mentioned cases will be taken in consideration. And in both cause number 2025 CR 011309A and 2025 CR 011311C, there's an affirmative finding of deadly weapon. And each of the cause numbers, have both parties had a chance to review the PSI report?
Yes, Judge.
Any objections to the PSI report from either party?
The only thing we'd like to point out, Judge, is there was some question about whether he had prior gang activity, and he does not. I think they checked that he did, but they did say it was questionable. And he is telling me he has never been in a gang.
And state, do you have any witnesses?
No, Your Honor.
Defense, the court has reviewed the letter from the defendant, which is the court's understanding that the state had no objections. So I've reviewed that letter. Defense, any witnesses?
We do, Judge.
All right, you may call your first witness.
We would call Mr. Hernandez's mother. Against the counter.
Hello.
Hi, ma'am.
Hi. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Giovanna Magaha.
All right, I'm sorry.
Giovanna Rebecca Magaha.
Could you spell your last name for the court reporter?
MCGAHA.
Thank you. You may proceed.
Mrs. Magaha, how are you related to Adrian Isaac Hernandez?
I'm his mom,
Okay, and how old is he?
19.
Okay. And could you tell the court where you live
I live in Smiley, Texas,
and what county is that in,
in Gonzales,
of that town?
in between, I think like 500. I mean, it's a small town, nothing's there.
Okay.
Like 2 schools and a Dollar General.
Okay, and if the court were to grant probation to your son, is that where he would be living?
Yes,
Okay, and there's a school there for him to attend?
yes.
Okay, and could you tell the court why you believe that Adrian should be on probation?
This ain't an eye opener. I'll be the first to. I've been praying hard, and with my faith and his faith, I mean, we've been just striving a long road. But I know God is good, and I got my family all in church with prayer and faith, and I got my mom home with me too. So, and I feel also changed. So I'm learning new things too. But they're all going. We have actually a lot of our families together still, and peace. I'm missing peace.
So, Mrs. McGaha, the court's going to want to know how it is that Adrian kind of fell off the path and how you're going to get him back on the path.
Well, I have a day and night with me and my husband, and I always take him. That's why I work at night, so I can take appointments for all my kids. So I can deal with that part in the morning if needed. Finances, I know how we're able to finance if we need help with that. There's people that can help us if needed. Finance wise. Or I do try to do overtime so that I can achieve those funds to be able to put that there as well. And then the church has been very helpful and helping us with our children, as well as the school that my children are in, with support and helping us with organizations outside of school to get them in right structure with speech, or any things that they're needing for their health issues or mental states as well.
And was your son in special classes?
Yeah,
Okay, is that a 504 designation, do you
that
know?
was one of them. And he did have also behavior from his ADHD and stuff like that.
Okay, and how high did he get in school?
Well, he repeated 9th grade for a good minute. But they ended up passing him through to 10th grade, but that was the last of it. But they only found record here when he was trying to go for GED only for the 7th grade. So we would have to find a way again, which is very possible, to be able to do so.
And you're willing to do whatever it takes to get him back on track educationally?
Yeah, I mean, I have been, and I haven't let go yet. I'm still here.
And if the court sees fit to grant him probation and puts your son in different programs to try and assist him, will you all be able to transport him or
Oh,
do
yeah.
whatever is necessary?
That's what I do for my kids, though.
And how many other children do you have?
I have 3.
And what are their ages?
5, 4, and 16 months.
We'll pass the witness, Judge. Hang on.
Ma'am, I have a couple of questions for you. Okay, so you stated that you live in Gonzales County, Texas, is that correct?
Like the outskirts of it.
Okay, and how long have you lived there?
Going on 6 years.
So what year did you live there?
2020.
2022 or?
The month I don't, but I know the year is 2020.
Oh, 20, okay. And so regarding your son, I mean, he's 19 now, but this is not the first time that he's
Right.
been report, correct?
Understood.
So he's been involved with the juvenile system since 2017. You'd agree with me, right?
I don't know the year, but I do know that it's been a while.
Okay, and so before you lived in or in the outskirts of Gonzales, Texas, were you living here in San
Oh,
Antonio?
yeah.
And was he living with you during
Yes.
that time? Okay, and so I guess my question to you is, back in 2017 and 2018 and 2019 and 2021, and 2022 and 2023, all of the years that he was involved in the juvenile system.
Right.
He was living with you up until 20, is that correct?
Probably before that. I don't remember when, because I got in a major car accident and I had to get surgery for that, and then everything came back.
Okay. And so he was much younger than
Right,
and he was still picking up charges under your supervision. Is that
Right.
fair to say?
I wouldn't say I was the best to the fullest like I am now. I'm a lot more mature. I've grown up a lot more since I was as a young mom too. And at the same time, he was a lot immature himself, which he needs still growing up, maturity wise, on that specific end. So, and then due to the, and then at the
I'm
same.
gonna ask you a question.
Oh, yes, ma'am.
Thank you. And so during the time when he was involved in the juvenile system, he was also ingesting illegal substances. Were you aware of that?
No.
Okay, and he's living with you during this time?
He do some runaways, so I mean, I would have to do those things too,
Okay.
on that end to put reports.
And so I guess my question to you is what's gonna be different now than before when he was involved in the juvenile system and under your supervision, still committing crimes? But if I'm understanding you correctly, you're saying that you're more mature now.
I'm a lot more mature. I have God on my side, that's one. I know I'll succeed with my son. That'll be number one. And then, two, I have matured. I have a husband that's he stands strong, and I stand right beside him. And as a whole, we succeed with our children. And we have moved our environment from a quiet place, peace. It's a whole different ballpark from living in this city over here to over there.
Okay. And you're aware that your son was on probation for the offense of evading arrest and detention with a vehicle, which is a felony offense, and that occurred in 2024. Were you aware of that?
I don't remember the year.
But you know that he's on felony probation right now. Do you know that?
I'm not too great with the law too much, but I know he's been in trouble most of the time.
Okay. So he's on felony probation, which means that he's gone before this court and entered a plea, and this court put in place different programs for him to abide by.
Yes, ma'am.
Okay, and he has not done that. Are you aware of that?
Yes, ma'am.
Okay, because he went out and committed an aggravated robbery ×2. You're aware, right?
Now I know that there's been 2 aggravated robberies. Yes,
Okay.
ma'am.
Okay, and so my question to you is, do you think that it's fair, or do you think that it's justice for somebody who's already on felony probation that has shown this court that they have no intention of complying with its rules? Do you think that it's fair for the court to give us probation for a second?
I mean, that's what the judge, I mean, I can't give that answer because, I mean, really, because I'm not the judge to say so, but I can say I'm there for my son.
Okay, that's fair. Thank you. We pass the witness.
No further questions, Judge. Thank you so much for giving me some insight into your son.
Okay.
All right, call your next witness.
We would call Mr. McGaha.
All right, friends, I wasn't intending on doing 4th hour content, but we stumbled into this. Assuming it doesn't drag on forever, we'll see it through.
Could you raise your
I'll
right
keep
hand
you
for me,
updated.
please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so I can hear and the court reporter can hear. If you'll state your name for the record.
Stephen McGaha.
All right, defense, you may proceed.
Mr. McGaha, how are you related to Adrian Isaac Hernandez?
I'm his stepdad, but I've been in his life since he was around 2.
Okay. And just to cut to the chase, Mr. McGaha, you know that we are here because he has picked up some felony offenses and he has a motion to revoke his felony probation, correct?
Yes, ma'am.
Okay. So the question before the court is, what is going to be different this time if the court were to give him probation and put him on deferred adjudication? What can you assure this court that's going to be different this time to keep him out of trouble?
Well, he's coming back home.
Okay.
And I run a very, very strong household, and he has completed probation when he was staying with us too. And when he did do that, he was living with us.
Okay, and so you're talking about some of the priors that he's had.
Yes, ma'am.
Okay, and the court has a whole list of those And a number of those were dismissed or rejected, correct?
Yes, ma'am.
And did he complete a couple of deferred adjudication probations under your watch?
Yes, ma'am.
Okay. And are you willing to do whatever it takes to keep him on the straight and narrow, should the court grant him one more opportunity to try and behave on one of her probations?
Yes, ma'am.
Okay. Is there anything that you would like to tell the court that you know is going to be different this time to guarantee or for the court that he's going to be able to be successful?
I mean, he has been successful with me because I do see him, because that is my son. So he does listen to me a lot. And like I said before, when he was staying with us and with me, he did. He had a couple of little hiccups, but he was very, very successful when he was at home. So if he does come out, then he'll be coming home. Because I run a very, very tight ship, especially with all of my kids.
What kind of work do you do, Mr. McGraha?
I am a farmhand.
Okay. And would you be able to get Adrian some work?
Yes, ma'am, I would.
And would you be able to make sure that he makes all of his appointments and that he gets back on track educationally?
Yes, ma'am. And then on top of that, I'm getting my wife her own vehicle upcoming soon. So she'll be having that. And then I'll be having my truck. So, and then I'll have my work truck too.
Okay. Is there anything else you want to tell the court?
My son, when he is home, he is very, very successful, especially when I am there. I am very, very stern with him. You can even ask him. He listens to me a lot more because I guess I just have that dad figure for him, that father figure. And I really do want my son home. If he comes home, I guarantee he will more 90%, almost 100% that he will be successful.
We'll pass witness.
All right. State.
Yes, so you've been in the defendant's wife since he was 2 years old. It's about your testimony.
Yes, ma'am.
Okay. And so your wife is the individual that testified before you, correct?
Yes, ma'am.
And she testified that you all lived here in San Antonio, Texas until year 2020. Is that accurate?
Yes, ma'am.
Okay. And so then both you and her moved to the outskirts of Gonzales, Texas.
Yes, ma'am. And then we purchased our own property.
Okay. And that's where you're living
Yes, ma'am.
current, correct? Okay. And so I guess my question is, why was the defendant not living with you at the time that these offenses?
When he wasn't living with us,
Well, why didn't he go with you in 2020?
in a 2020, it was like a big old thing that just happened, and incident that happened at the house. So I had to move my family out, and then my funds stayed with his grandma, if I'm not mistaken. And then he did stay with us a couple more times after that. And then when he was staying with us, he was in school. He had everything done, and everything was good. And then my son is he almost had it completed, and then when he turned 18, I do believe, that's when he fully moved to San Antonio.
Okay. So when he turned 18, then he moved out from you and his mom and returned back to him.
Yes, ma'am.
And so it's your testimony that, you know, he's been successful in the time of living with the contract. And you described the problems that he's had as hiccups. But you would agree with me that there's some pretty big hiccups, right?
I had some pretty big hiccups too.
Okay, that's not what I'm at. Do you think that it's a bit, would you describe it just as a hiccup, an aggravated robbery where he knows that his friends have guns and they're stealing property from people?
On
Is
that
that
end,
a
ma'am,
little
I
hiccup?
do not know. I do not know because I was not there.
Well, I'm asking you.
So,
Do you think,
on-
listen to my question, do you think that him acting along with his co-defendants, if he sees his co-defendant has a gun and they're pointing it at an innocent civilian and taking that civilian's property, do you think that is a big hiccup or a little hiccup?
I couldn't even see my son doing that in the first place.
Listen to the question.
That is the,
Is
I'm giving you
it
an answer,
the
ma'am.
facts that I described to you, is that a big or little hiccup?
On that end, I do not know, ma'am.
Is it a big or little hiccup?
I was not with him.
The facts that I'm describing to you, if somebody pointed a
can't
gun
say
in your
that,
face
ma'am.
and took your property, would
I
that be a
cannot
big or
say
little
that.
hiccup?
I cannot say he did or did not because he was not with me.
Asked him as the judge and argumentative.
Excuse me. So just listen to the question and answer the question, okay? All right, you can ask your question.
Facts that I've described to you, hypothetically, if somebody acted along with another co-defendant and one co-defendant had a firearm and pointed it at an innocent civilian and the other person started taking that civilian's property, would you describe that as a big or little hiccup?
I would call that as a big hiccup, yes, ma'am.
We pass away.
We have nothing further.
All right, sir. Thank you for giving me some insight into your stepson. I appreciate you coming in to testify.
Yes, ma'am.
All right, thank you. Call your next witness.
We have no further witnesses.
All right.
Unless, did you want to say anything to the court or do you want to just rely on your letter?
Just want to say that.
Well, here's the thing. If you want to say something to me, then I'll have to swear you in and the state will get a chance to ask you questions. Sorry. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Adrian Hernandez.
All right, and before he begins talking, did you want to confer with him a little bit about whether he wants to say something to the court or not?
Yeah, if I could, just
Yes.
briefly. Want to do that? Okay. Judge, he'd rather just rely on the letter that he gave the court.
All right. Then let me call this cause number because I see that there were not pleas entered and it's the motion to revoke. All right, the court is calling 2024 CR 007176. Mr. Hernandez, I'm going to show you what's entitled the motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Oh, yes, ma'am.
Are you the same Adrian Isaac Hernandez who was placed on community supervision in 2024 CR 007176 for the offense of evading arrest or detention with a vehicle on August 5th, 2024 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state, you may proceed.
Violation of condition number 4 in Bexar County, Texas, the defendant Adrian Isaac Hernandez did then and there failed to report to the supervision officer as directed for the month of May of 2025 in violation of conditions.
How do you plead to that? True or not true?
True.
We'll waive it down in there.
Any objections to the waivers?
No objections.
Did you understand by pleading through the violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 6 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement with regard to that motion?
There's revocation and for 6 years in prison.
All right. And defense, the court will, with regard to that, I'm assuming you want him continued.
Correct, Judge. We'd like it to run all concurrent with what his new offenses are.
All right. And then state, since you're opposed, I'll hear your argument, and then defense, I'll hear your argument for the cases that he's here to be sentenced on, as well as the motion to revoke. I think it'll flow smoother with that. All right, state.
Judge, so we are asking that you deny all of his applications and sentence him to 12 years in the prison and the aggravated robbery cases, and then 5 years in the prison on the collision case. Your Honor, I do appreciate in reviewing the PSI that this defendant did somewhat take responsibility for his actions. And he did enter into a plea, and his role was taken to account in the plea bargain. That's why he was given a top 12 post, because he took responsibility and because he's not the person that had the fire. and the evidence that was stipulated to, he's acting with two co-defendants, and they were engaging in burglary of vehicles and local businesses, in San Antonio over on the far west side. And basically, they were going and pulling door handles and seeing what they could get into. And an uninvolved innocent bystander tells him to, hey, knock it off. And his co-defendant points a gun in that person's face and tells him to get the fuck out of here while he is receiving property from the other co-defendant. Your Honor, he was already on felony probation, and this court has given him an opportunity to rehabilitate himself and be a productive member of society. And he has failed to do that. And if the court were to grant his applications, he would fail to do it again. Based on, and then also in the collision case, he's driving recklessly, crashes into somebody, causes them an injury, and then he doesn't turn himself in for any of this. SAP has to go and get him out of his house. So he can take responsibility in that regard, but in the PSI he did, which I appreciate, but we are asking you to deny his applications and send it to 12 years.
All right, Judge, I think that the state has actually hit the nail on the head. He is extremely remorseful, and I think that the court can see that in the PSI, which is kind of unusual. You don't really see that level of remorse or taking responsibility for actions in my experience anyway, in these PSIs. I think this has been a tremendous wake-up call. I think that the family has rallied and is stepping up to take some responsibility to make sure that he can stay on the path. He has definitely gotten off the path. There were definitely people that were hurt as a result of his actions, and he is very sorry for that. I think that he has had a bad time in jail, and I think that this has shown him that he cannot go down this path, that he cannot be with these types of people, that he needs to live in his Smiley, Texas with a population of 500 and get his GED and go to classes and get a trade and go to work and stay on the straight and narrow. And I think he needs his dad, who appears to be a very strong father figure, to be in his life and to keep him on the straight and narrow and make him a productive citizen. And I know the court will have a number of programs and things to assist him with that. And I think that he is receptive to all of that. And so we are asking the court to grant his deferred adjudication and to run it concurrently and to keep him on probation in his evading case. And in the alternative, Judge, then we're asking for the lowest possible sentence that the court could deliver.
All right, Mr. Hernandez, I want you to know that I've heard all of the testimony. I've internalized everything that has been said. I just don't think that you're a good candidate for probation. So in cause number 2024 CR 007176, the court will revoke. The court is finding for true. The court will sentence you to 6 years in the prison, give you credit for any time served. There's to be no contact with Gustavo Perez. This is the run concurrent with 2025 CR 011020, 2025 CR 011311C, 2025 CR 011309A. I request to the therapeutic community, and there's to be no residing with minors. Did you review the document in that case entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You do have a limited right to appeal in that cause number based upon the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 011309A. Court is going to deny your motion. Court will find you guilty. There's an affirmative finding of deadly weapon. There's a $2,000 fine. Time and money will run concurrently. This is the run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C. Taking consideration 2025 CR 0133, I'm sorry, 2025 CR 011310C and 2025 CC 009777. There's an affirmative finding of deadly weapon. Court will sentence you to 12 years in the prison. Give you credit for any time served. Restitution, if any, to Shamari Moore. There's to be no contact with Lincoln Gage Mertens, Oscar Carvajal Jr. Is there anything else with regards to sentencing under that cause number?
No, I don't believe so.
And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes,
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 011311C. The court is finding you guilty. The court will sentence you to 12 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C. Take in consideration 2025 CR 011310C and 2025 CC 009777. There's to be restitution, if any, to Paul Hike. Court will recommend the therapeutic community. And there's to be no contact with Lincoln Gage Mertens. And that cause number, is there anything else with regards to sentencing?
No, ma'am.
I'm sorry, there's an affirmative finding of deadly weapon.
Just the other thing is that we've asked for a no contact order with the other co-defendant, which is Oscar Carvajal.
All right, and no contact with Oscar Carvajal. And no residing in households with minors.
Is there a fine on that one?
No. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes,
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 011020. Court will find you guilty. Court will sentence you to 5 years in the prison. Give you credit for any time served. There's a $2,000 fine that will be probated. This will run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C. Take in consideration 2025 CR 011310C, 2025 CC 009777. There's to be no contact with Lincoln Gage Mertens and Oscar Carvajal. There's to be restitution, if any, to Mia Alaman and Sandra Marin. And the court will recommend the therapeutic community, no residing in households with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. I know it's a lot of time and you're very young. When you go to prison, do not become institutionalized. Go there, keep your head down, try to get your degree. I will tell you, I've had clients before, and the best certification you can get, it may have changed, is welding. Because with welding, they get paid a lot of money. It'll be something that you'll be able to support yourself on, okay? All right, good luck to you.
Thank you, Judge. May we be excused?
I need the...
All right, friends, I do need to fly, but hopefully he serves his time well and gets his stuff together. We'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. We'll be back tomorrow morning for this live show, 9 a.m. Eastern, 6 Pacific, a half an hour early for channel members. Thanks so much for spending time with me today. Thanks for the generosity of those who did super chats and gifted memberships. Thanks for just hanging with us today. It's been fun. So look forward to seeing y'all again soon, but I got things I gotta go do. So see you later. Take care. God bless.